And it has not been listed.
No, my lord. To pardon me, Lord. Correction of date of birth.
The transfer matter, my lord, assignment of court number 10, my lord.
Transfer matter. The transfer matter is assigned to our court. To this
Court
court.
number 10. Just
Oh, transfer means? No, service matter or transfer?
my lord.
Say that.
Yes.
What is the urgency?
For this, my lord, my lord is a cancer patient and less than 2 years is service, my lord. He's transferring from Bhubaneswar to my lord.
So it will be taken up next week when Justice Patnaik joins. What is the urgency?
At any point, my lord, he may be relieved, my lord.
May pardon, my lord. This matter is assigned to court number 10, my lord. This is the Department of Proceedings. The petition will be terminated, my lord. Notice has been issued, my lord.
To mention, my lord, at 2014 matter, my lord, your lordship heard it in part in the last occasion. My lord, 6 to 34, my lord.
What is that matter?
My lord, it is about the approval of
कौन आ गया सर RSA ना repetition ना कौन तो सर कौन है
Pardon me,
कौन कौन sorry नहीं है what is the urgency
my lord, it is regarding the approval of post to third.
no not urgent no urgent
Pardon me, the urgent matter. In 2 cases, he has sent to custody. In one of the cases, he has been released on bail. In this case, he has been custody since more than 6 months.
yes
Pardon to mention, my lord. My lord, I am in VC, my lord. Weekly item 57, my lord. Yesterday, parcel the lordship had taken up 2 weeks after, along with CRLM 811, 813, 813.
ask somebody to give a cheat list this matter 2 weeks after along with so and so yes
well this is a transfer of matrimonial proceeding notice has been issued but there is no stay order here trial court is proceeding with the
all
supplementary list item number 1 fresh admission
My lord, petitioner challenging the process of selection and that the arbitrary action by the opposite parties, my lord.
yes what are you challenging
My lord, challenging the order by notice number 1
selection proceeding advertisement is
9-243,
issued
my lord.
Joy Patna inviting application then council shall take instructions that may have been taken pursuant to such argument. Yes what action was taken
My lord,
you were directed to take steps I mean take instructions and
I
after
have
cancellation of the earlier selection proceeding an advertisement was issued on 6/4/2023
my lord, yes,
inviting applications
yes.
so you were directed actually you were directed to take instruction with regard to steps that may have been taken pursuant to such advertisement
My lord,
what action was taken
I have received the instruction.
yes what
But in this case, my lord, the selection is already over in person to the new advertisement, but that information which we have received, my lord, that was on 21st March 2024.
21st March. Achha. This order was passed on 14th March. It was directed to be listed on 4th April. For some reason, it was not listed.
My lord, that 21st March, my lord.
Oh, so 21st March.
Immediately after the lordship directed me
Yes,
to
yes.
obtain the instruction.
But unfortunately, the matter was not listed.
Yes, but there at that particular stage, my lord, as on 21st March, the selection was over, but no engagement was there.
Anyway, what is the ground of challenge?
My lord, challenging they have rejected the petitioner on the ground that barred by jurisdiction, my lord. That's not within the jurisdiction of the area.
Cancellation of list as per Annexure 5. Earlier, there was a selection.
Yes,
selection process.
my lord. I pray, my lord, one thing.
Yes,
My lord, the appeal provision is there. Delay may condone and petitioner.
no. What have you challenged? Let me first find out.
My lord. May I be permitted to place, my lord?
This decision is of February
My lord,
2023.
one advertisement was
No, this decision is of February. The impugned decision is of February 2023. I don't think the new guidelines would apply.
My lord, may I permit?
Yes.
The decision, there was an advertisement. In terms of that advertisement, the different applicants submitted their application. The selection committee found that not a single applicant belongs to that particular service area. Out of, there are 3 categories. As regard the Anganwadi Central Lakhavali, 7 candidates had applied, out of which one of the candidate was absent on the day of scrutiny. On the date of the scrutiny, out of the remaining 6, 5 number of candidates are out of service area, including this present petitioner. And the other person, my lord, Bhumita Banwa, she had produced a fake certificate.
Yes.
So for that reason, the selection was, the process of the selection was cancelled and followed with the new advertisement, that is annexure 3.
So what is the ground of, what is your ground of challenge?
My lord, my ground is the present petitioner belongs to that area after her
Where have you said that?
after her marriage.
Where have you
My
said
lord,
that?
I'm annex 1 Susila Bhatra Government of Residence Certificate in favor of the petitioner, that is page number 11.
Residence is not
Resident certificate হলে হবে না।
service area.
So the survey list will show whether you belong to that service area or not. That is more relevant.
Yes, my lord.
You may belong to the village,
My lord.
but you have to belong to that particular service area of the Anganwadi center. So that, where have you pleaded that, or where is the document to show? Unless I am satisfied about that, I will not grant you the liberty to file an appeal. It is pertinent to mention that the petitioner having married to Usman Banua, a villager, is residing with her husband since long,
My
and
lord, on
it's started
paragraph
the
number
petitioner
5, my lord.
been issued with residence certificate and Aadhaar card. He is a resident of village Lakhbahali. Lakhbahali. No, the village is all right.
My lord.
Village is not good.
My lord.
Only village is not good. In a particular village, there may be multiple Anganwadi centers.
Yes, my lord.
So, to qualify for a particular Anganwadi center, you have to
Belong
be a
to that.
resident of that service area.
My
So, where have you said that? You have not said that.
My lord, kindly taken up, my lord. Tomorrow, my lord, I will verify it.
Let this matter tomorrow is prayed for.
Published.
I don't know to
Well, the petition prayer before you lordship to transfer the criminal proceeding from Jajpur court to any other court to your lordship may please, my lord, preferable to Cuttack, my lord. On the ground that there is not being possible for fair trial because the life is under the threat of the informant. The background of the case that the informant has filed this case to threat the opposite party to collect money from them to maintain his wife. The wife is no way connected to the opposite parties. There the case is not against the father-in-law. The opposite the petitioners are the brother and the brother-in-law, father and the brother-in-law, uncle and the brother-in-law of the wife, his wife. They are not he is not entitled to get any maintenance from his uncle when the father-in-law is alive. Father of the his wife is alive. But he has intentionally filed the case. The moment they will leave, they are reaching the Jajpur court, giving them the threat to collect money from them. This is the FIR statement, 161 statement, and the FIR allegation. Your lordship may kindly see that she admittedly, she has got.
You are the accused.
Yes, my lord, accused. Accused, I'm କିଛି ଦବାର ନାହିଁ ଆଜ୍ଞା, ଆମେ ତାର
କ୍ୱାସିଂ ରେ ଆସୁନାହାନ୍ତି, କ୍ୱାସିଂ ଫାଇଲ କରୁ।
କ୍ୱାସିଂ ରେ ମୁଁ ସେଇଟା କ୍ୱାସିଂ ରେ ଆସିଥିଲି, ସେଠି ଆପଣଙ୍କର ପେଟିସନ ଦେବା ପାଇଁ ଅର୍ଡର ହେଇଛି that I have not discharge ପେଟିସନ ଦେବା ପାଇଁ 506 is there, କିନ୍ତୁ ସେଠି ପହଞ୍ଚିଲା ବେଳକୁ the local lawyers are under the influence of the informant and
All the lawyers are under the influence of the informant.
outside lawyers they are not being also allowed there.
No.
ମାନେ any court ଯାଜପୁର ରୋଡ କୁ ଆସିଯାଉ, ନହେଲେ ଆପଣ ପାଣି ଚଣ୍ଡିଖୋଲ any other court. My
The
lord,
petitioner is an accused.
my lord,
No, sorry. The petitioner is an accused in CT number 1949 of 2022, corresponding to Jajpur PS case number 309 of 2022, presently pending in the court of Learned SDGM, Jajpur, for the alleged commission of offence under section 506(34) IPC. The petitioner seeks transfer of the said case to any other court, mainly on the ground that the case has been lodged falsely. Again, the case has been foisted falsely against him, and
my lord, petitioner before lordship as man of Jagatsinghpur.
he apprehends threat to his life in case he is required to visit Jajpur to attend the court on the date of posting of the case. is further submitted. It is submitted that the petitioner is also a resident of Jagatsinghpur.
Two petitions are there. Two number of petitioner, accused, two numbers of accused.
Petitioners for one. It is also submitted that no lawyer of Jajpur is willing to represent the petitioner in the case. CORAM. After considering the submissions and the materials on record, this court does not find the grounds cited by the petitioner as valid for transfer of the proceeding. Stop. As regards the so-called threat to his life, it is always open to the petitioner to take help of the local police as also the court for necessary protection. Secondly, the petitioner can also approach the legal services authority to engage a lawyer to represent him in the case. Also, see the continue also by taking the by bringing such fact to the notice of the court. Further, the petitioner can also appear through virtual mode if by seeking necessary permission of the court. For the foregoing reasons, therefore, this court is not inclined to entertain the application for transfer, which is therefore dismissed. Yes.
Item number 3.
The lordship disclosure of which is that observation.
ऊपर पर observation है आपने added affiliate किया है?
Item number 3. May I please?
That ছাড়ি দিন সে জায়গাটা আপনি ভিতরে আছেন তাহলে আপনি এপটু পড়ে আসুন
I may appear in this case today by file may be number.
আগে নোটিস দিয়েছিলেন
No, it's fresh materials.
ফ্রেশ ম্যাটার
Fresh matter, earlier my lord has disposed of the case. Earlier a transfer case, the present petitioner has filed an application before this civil judge.
you were the wife.
I am for the wife.
Yes.
And earlier the my lord has passed order, similar order. So he, in this particular case, now the present case is infructuous.
Okay, where is that order?
How that is in fact it is a case arises of protection of women for domestic violence act lordship. And section petition has been filed by the wife is here lordship. My respectful submission so far.
Just go through. This was filed again by the wife, Lopamudra Giri.
No, this case has been the transfer. Yes, Lopamudra Giri to transfer the CP case from Sub-Judge Nilagiri to Cuttack.
No, that was a MAT case.
That is
That is a
section
matter.
9.
And in that case, where he has filed in two cases, the wife has filed a DB case and also 125 CRPC which is pending. And in both the cases, they have appeared and filed their counter. And conciliation has already been filed. On that particular ground, my lord has transferred the case from Nilagiri to Cuttack. Now again, they have filed another petition TRPC CRL that the case has been transferred from Cuttack to Nilagiri.
It was directed to be transferred from Nilagiri to Cuttack.
Cuttack.
To that MAT case 31 of 2023 has been transferred.
Has been transferred.
Now this petition you have filed.
No, I am not filed.
I am filed.
You have filed.
Husband has filed.
No, you said you are appearing today.
Appearing and
So far
and
this
filing
case is
counter.
concerned.
Acha. Oh,
So far
very good.
this
Concern.
case is concerned.
No, also DB they have appeared.
But this you want transfer of
As a
criminal proceeding number 219.
that is complete his argument so that I start my.
No.
His
All right.
opposite
So
party in this complete.
My appearance in this particular.
yeah, that's all right. But now you want transfer of criminal proceeding number 219
DB case.
from Cuttack to Nilagiri.
Nilagiri.
Yes, ma'am.
Already this court has already taken.
So far the section 9 application lordship given direction for transfer from Nilagiri to Baleswari lordship, from Nilagiri to Kottake lordship. That case is now, lordship, I preparation for filing an appeal because the hardship is that, lordship. Whatever cause of action, lordship, the wife is belongs to the district of Balasore.
Why this transfer was allowed? Let me just read out. After hearing both parties and on consideration of the facts of the case, I am inclined to allow the prayer for transfer mainly on the ground that two cases by the petitioner wife at Cuttack are pending.
That's true.
One of them is that this DV case.
Lords.
So how can again be considered?
This is a case under section 12 of the Protection of Domestic Actions.
Yes.
And says judicial part is section 27. Although there is a three criteria, lordship, that the temporarily or permanently resides by the any of the agreed persons, and so far as the cause of action arises, lordship, and so far the business place of
case of transfer of cause of action.
Here, lordship, in the protection of domestic, husband is not the only petitioner, lordship, or the opposite party before the court below. Parents, those are old aged person, lordship, senior citizen, unable to move. And in these circumstances, lordship, if they have appeared here, lordship, to fight the case, then definitely cause hardship to them, lordship.
Petitioner, senior citizen, one 60.
Husband is lordship. It can be easy. So far the parents are concerned. They are the opposite party in the domestic.
They don't have to appear every day. They don't have to appear every day in the case.
If your lordship permit me, lordship, so far virtual mode is concerned, then we can cooperate. And second aspect also a glance. Second aspect. So the cause of action part is concerned, lordship. This is the fake address has been given by the wife and file this proceeding in here, lordship. Now the entire cause of action so far domestic violence is going, there must be a domestic incident.
That is raised before the court.
See that the domestic incident arises at Mitropur under the jurisdiction of Balasore district, lordship. And now the case is filed here. Entire witnesses are there, lordship. They are not here, lordship. Now, what compelling circumstance to say the informed to file this proceeding here instead there, because the DR report is most necessary. So far proceeding initiative is concerned, also 12 of the Act is concerned. That is also not there. So, however, only my hardship so far the parents are concerned. But so far the petitioner already a lordship transferred to other proceeding here and the subsequent proceeding pending is there. So I may be protected so far if require my appearance, that can be through virtual mode.
Yes, the petitioners seek transfer of criminal proceeding number 219 of 2023 filed by the present opposite party in the court of learned SDGM Nilagiri, section 12 of the PWDVI. The court of learned JMFC 2 cog taking in the court of in the court of under section 12 of the PWDV Act. Therefore, transfer is where it is prayed that the case be transferred to the court of learned SDGM Nilagiri on the ground that the petitioners are residing within the territorial jurisdiction of the said court, and the cause of action also has arisen there. Further, the petitioner number 1 and 2 are elderly persons. 1 and 2.
1 and 2 years.
1 and 2 are elderly persons, and it would be inconvenient and difficult for them to appear before the court at Cuttack. Considering this court, after considering the submissions, is not inclined to treat the ground cited as a valid ground for transfer, for the reason that the petitioners are not required to personally attend the court on each date of posting of the case. And secondly, they can also appear through virtual mode by obtaining necessary permission of the court. That apart, another case filed by the wife opposite party, being MAT, case number 31 of 2023, is also pending adjudication before the family court at Cuttack.
And also another 125.
Taking into consideration all these facts, this court is not inclined to allow the prayer for transfer. Stop. The transfer application stands dismissed. It shall be open to the petitioners to seek permission of the court to appear through virtual mode.
If necessary arises.
Further, the court below shall not insist upon the personal attendance of the parties unless absolutely necessary.
My appearance be noted.
I will listen to Sri Prabhas Chandra Jana
Anjan Kumar Jana.
enters appearance
Be
for
noted.
the petitioners after obtaining
Be
no
noted.
objection
Be
from the
noted.
previous counsel. Separate. Heard Sri P.C. Jana, learned counsel for the
AK Jana.
petitioner, and Sri Anjan Kumar Jana,
Anjan Kumar Jana.
and Sri Anjan Kumar Jana, learned counsel for the opposite party. Thus,
Document. Document.
Item number 4.
May it please, Lord. May I plead, my lord, this matter may be taken up on Friday along with TRPC number 428 of 2020.
Friday means tomorrow. Huh? Friday means to आज बुधवार. अच्छा हो.
Because I have instructions that the divorce case pending was posted yesterday for orders. Today they will obtain the orders.
All right.
If their order is passed, then both the TRP will be infectious.
As prayed for, list this matter on
28.
28th June, along with TRPC
428 of 2023.
428 of 2023. Yes.
Overlays.
Item number 5.
Please, your lordship. That's the lady petitioner seeks transfer of the civil proceeding pending in the family court Cuttack at page 22, Annex 3, your lordship, filed by the husband under section 13 of Hindu Marriage Act to the Court of Family Judge Bhubaneswar. Your lordship, the factual factor is that your lordship may turn to page 12. Earlier, wife has filed a case in CP number 9 of 2023 before the family court Bhubaneswar, your lordship. And at Annex 2, the opposite party has appeared in that case. Annex 2, your lordship, and he has also given his address, that Bhubaneswar, opposite party husband. And during pendency of that case, again he filed another case before the family court Cuttack at page 22.
Transfer होगा.
Transfer हुआ था ना, earlier case is pending before family court Bhubaneswar. Wife filed करते self some section earlier. Sethere he has appeared, and knowing this fact, again filed a case here under section 13.
So this is pending.
This is pending. In
CP 9 of 2023 is pending.
Section 9,
CP 9 of 2023 is pending.
This is pending before
Take notice. Issue notice to the opposite parties. Who is opposite party number 2?
Opposite. He has impeded opposite and another person as opposite party number 2. Husband has impeded.
Is it necessary?
He has impeded, though. So I have impeded here, and it was a defect. Defect as to answer the.
All right. Issue notice to the opposite parties by registered post by speed post, fixing a short returnable date. Requisites shall be filed by tomorrow peremptorily. List this matter on 24th
July.
24th July. Yes.
Interim.
In the meantime, if any application for adjournment is moved by the petitioner in the court below, the same shall be considered, having due regard to the date fixed for hearing of this case.
Item number 6.
May I please see an application for transfer in MSC case number 7 of 2021, which is pending before the learned judge, the district and session judge, come MSCT, your lordship, Borgar to the learned judge, district judge, Cuttack, your lordship, session judge, Cuttack, your lordship.
Why do you want it?
Your lordship, the petitioner is suffering from is the 100% disability. Annex 3, your lordship, kindly see, 22, page 22. And he is suffering from
All right.
paralysis and
All right, Mr. Mathi, take notice. Issue notice.
your lordship.
Issue notice to the opposite parties by speed post, fixing a short returnable date. Requisites be filed by tomorrow peremptorily. List this matter on
24th July.
24th July.
Item number 7.
May I please? In this case, my lord, the petitioner being the wife seeks to transfer the divorce proceeding filed by the husband to Judge Family Court Jajpur from the Judge Family Court Baleshwar. And my lord, it is very hardship on her part to travel a distance more than 100 kilometer. And her father also ill. Now the wife is residing with her father.
Well,
At
issue
that-
notice by speed post. Issue notice to the opposite party by speed post, fixing a short returnable date. Requisites be filed by tomorrow peremptorily. List this matter on 24th July.
Item number 8.
My lord, the petitioner, the wife of the opposite party, my lord, filed petition for transfer from family judge Jaipur to family judge Nabarambur, my lord.
Yeah, 44 kilometers.
My lord,
Only 44 kilometers.
8 months male child is there, and also other criminal case is pending at Nabarambur, my lord.
Well, issue notice.
Criminal case.
Notice कर दिया तो आइए adjournment.
State.
Adjournment हो तो आपने देखिए.
Item number 9.
Sir, in this application, my lord, the petitioner being the wife, my lord, seeks for transfer of CP case number 3722 of 2023 in the court of the Lord and Judge Family Court of Baleshwar, Baripada, my lord. The petitioner is staying at Rairampur, my lord. She has no independent source of income and 2 criminal cases is pending, my lord, at Baripada, my lord. One is
The distance between Baleshwar and Baripada is
there also
ये सुनो ये मैं कथा सामने
my lord. Sorry.
मैं कथा मझे क्या कुछ देगा when the court is speaking can't you keep quiet Mr. Das?
My lord.
The distance between Baleshwar and Baripada is less than the distance between Baripada and Rairampur. Baripada रो Rairampur है 80 किलोमीटर, बालेश्वर रो Baripada है 60 किलोमीटर.
My lord.
तो आपण Rairampur रे जदि रहउचंती आपण where do you want it to be transferred?
Baripada.
Issue notice to the opposite party. तुम कर दो है adjournment. Speed post खाली requisites adjournment. Yes.
Item number 10.
Aye, my lord.
कॉल पर adjournment.
My lord.
Yes.
May I lord, sir?
This matter was yesterday.
Yesterday.
कौन थे लेते?
This is the matter relating to that 5.1, 5.2 that
Yes.
Shikha Karmi resolution.
Yes. Did you get that judgment?
Yes.
Is it covered by that judgment?
My lord, I may be permitted to place one thing more.
Yes, please.
Which is factually, it is admitted by the petitioner in this case, what I got back. Prior to this case, he had filed another case. There is a direction by this honorable court to submit a fresh representation and to dispose the same in terms of Bhavita Sakti case. So that direction is very much available, my lord. When, according to him, a content proceeding is pending. Now, in the meantime, he has approached before this honorable court, placing reliance upon the subsequent decision of your lordship. So that is a decision, my lord, wherein your lordship has stated, observed that there are unfilled vacancies, and as against the existing vacancy, since the process of the selection has been stopped in the midway, as a result of which the case of the petitioner in that case could not be considered properly. So it is once again it is to be considered, and she may be appointed against the existing vacancy. To that, my lord, I have the information, my lord, with respect to the unfilled vacancies. Already an advertisement on 10/9/2023 has been floated for about 20,000 vacancies, and to the best of my information, my lord, that is also inclusive of the unfilled vacancies of those years. So my submission, my lord, because one representation is now pending for consideration according to as per the submission of the petitioner. Either I may be permitted to take the position in that case.
That will do. That will be better. Yes. बुझिପାରିଲେ?
ଆଜ୍ଞା ବୁଝିଲି ସେ ମାଇ ଲର୍ଡ ସେମାନେ ତ ଦଉନାହାନ୍ତି କିଛି
ଆପଣ ଆଉ ଗୋଟେ ରିଟ୍ ପିଟିସନ ଫାଇଲ କରିଥିଲେ ସେଥିରେ ଅର୍ଡର ହେଇଥିଲା ଯେ ଆପଣ ଗୋଟେ ରିପ୍ରେଜେଣ୍ଟେସନ ଫାଇଲ କରିବେ
ଆଜ୍ଞା
ଆପଣ ରିପ୍ରେଜେଣ୍ଟେସନ ସବମିଟ କଲେ
କଲି
ସେଥିରେ କିଛି ଅର୍ଡର ହେଲା ନାହିଁ ସେଥିରେ ଆପଣ ଗୋଟେ କଣ୍ଟେମ୍ପ୍ଟ ବି ଫାଇଲ କରିଛନ୍ତି କଣ୍ଟେମ୍ପ୍ଟ ବି ପେଣ୍ଡିଂ ଅଛି
ହଁ ସେକେଣ୍ଡ କଣ୍ଟେଣ୍ଟ ପେଣ୍ଡିଂ ଅଛି
ଏଇ ସେକେଣ୍ଡ ଫାକେଣ୍ଡ ମୁଁ ଜାଣିନି
ଫାର୍ଷ୍ଟ କଣ୍ଟେମ୍ପ୍ଟ କିଛି କଲେ
ମୁଁ ଜାଣିନି ଆଜ୍ଞା ଆପଣ ଜାଣିଥିବେ କିନ୍ତୁ ଅଧିକା ଯଦି ଜାଣିଥିବେ କଣ୍ଟେମ୍ପ୍ଟ ଆକ୍ଟ ପଢିଥିବେ ଯଦି କଣ୍ଟେମ୍ପ୍ଟ କୋର୍ଟ ଆକ୍ଟ ପଢିଥିବେ ଜାଣି ଆଇ ଡୋଣ୍ଟ ନୋ ମୁଁ ମୋର ସେ ଆଇଡିଆ ନାହିଁ ସେ ବିଷୟରେ ମୁଁ ଖାଲି କଣ୍ଟେମ୍ପ୍ଟ ବୋଲି ଜାଣିଛି ଏଇ ଯୋଉ କଣ୍ଟେମ୍ପ୍ଟରେ ଆପଣ ଗୋଟେ କଣ୍ଟେମ୍ପ୍ଟ ଫାଇଲ କରିଛନ୍ତି ହେଲା ସେ କଣ୍ଟେମ୍ପ୍ଟ ପେଣ୍ଡିଂ ଅଛି Pending ଅଛି ତ?
pending ଅଛି।
ତେଣୁ in the meantime ସରକାରୀ ଓକିଲ ନେଇକି ବୁଝିକି ଆସନ୍ତୁ କଣ ହେଲା ସେ representation ସେ representation dispose of ହେଇଯିବ।
Next week ରେ ରହୁ।
ସେ dispose of ହେଇଯିବ। ଏଇଟା ଆପଣ instruction ଆଣିଲା ବେଳକୁ dispose of ହବନି। And please consider it favorably.
Yes.
A man is running from pillar to post for the last so many years. Our case has my judgment been challenged in appeal, writ appeal?
To the best of my information,
Then it has to be implemented.
it should happen.
Either it is
Yes.
challenged and set aside or it has to be implemented.
Yes.
So in light of that, why don't you consider? No, I will not dispose of.
No.
I'll keep it pending.
Yes.
ଆପଣ ବୁଝିକି କୁହନ୍ତୁ କଣ ହେଲା?
ଏଇଟା next week ହିଁ ରହୁ।
Next week ରେ ଆସୁ ସେ ବୁଝିକି କୁହନ୍ତୁ।
My lord, ଆଏ ଟା ଟିକେ ଆଲାଉ କରିଦିଅନ୍ତୁ।
ଇଏ କଣ ହେଇଛି?
ଆଏ ଗୋଟେ ପୋଷ୍ଟ ରିଜର୍ଭ ପାଇଁକା ଦେଇଛି।
My lord,
ନା ଏଇଟା ଏଇଖିନା କରିହବନି କାହିଁ ଆପଣ ଯଦି ରିଟ୍ ପିଟିସନ ଆଗରୁ ଫାଇଲ ନ କରିଥାନ୍ତେ ତାହେଲେ ହୁଏତ କିଛି ଅର୍ଡର ପାସ୍ କରା ହେଇପାରିଥାନ୍ତା। ଆପଣ ଅଲରେଡି ଗୋଟେ ପାସ୍ ମାନେ ଫାଇଲ କରିଛନ୍ତି ଯୋଉଥିରେ ଗୋଟେ କିଛି ଅର୍ଡର ହେଇଛି। ସେ ଅର୍ଡରଟା ସମ୍ପୂର୍ଣ୍ଣ ନ ହେବା ପର୍ଯ୍ୟନ୍ତ ଏଥିରେ କେମିତି କରିହବ? ବୁଝିପାରିଲେ? କରିବାକୁ ଆମେ ମାନେ କିଛି ମନା ନାହିଁ
from
କିନ୍ତୁ
that, my lord, the advertisement is not on the challenge.
ନାଇଁ ସେ ପୁରୁଣା 2016 ଟାକୁ ଚ୍ୟାଲେଞ୍ଜ କରିକି ଯାଇଛନ୍ତି ଆଉ।
ନାଇଁ ଏଇଟା ଯୋଉ 2023 ର advertisement ରେ ଯୋଉଥିରେ କି ସେ ଚାହୁଁଛନ୍ତି post vacant ରଖିବା ପାଇଁ। Neither the
ସେଟାକୁ challenge
copy of the
କରୁନାହାନ୍ତି।
advertisement is there, nor that has been challenged.
ଠିକ ଅଛି ଆମେ ନେକ୍ସଟ ୱିକ୍ ଆସୁ ଇନ୍ ଦ ମିଟିଂ if necessary he will challenge it ଆଉ କଣ?
Yes, move next week ରେ ସବୁ
try to give him relief.
I'll do that, I'll do
My lord, ଗୋଟେ particular date ଟା
ହଁ ହଁ ନେକ୍ସଟ ବୁଧବାର ହିଁ ଆସିବ। ନେକ୍ସଟ ବୁଧବାର
3 ଜୁଲାଇ।
Sri S.N. Patnaik, learned AGA, submits that the petitioner had earlier filed a writ application being WPC number
9325 of 2023.
9325 of 2023, which was disposed of, granting him liberty to submit a fresh representation before the authorities. Stop. The petitioner accordingly submitted a representation which he claims has not been disposed of as yet, for which he has invoked the contempt jurisdiction of this court. Sri Patnaik shall obtain instructions as to the status of the representation submitted by the petitioner. कहाँ पर representation दिया था?
Opposite man, no one, my lord.
Before opposite party number 1, pursuant to direction of this court in the earlier writ application. List this matter next week.
Item number 11.
Thank you, your lords. Lords, petitioner, my lords, is a contractual employee working as a laboratory technician under Odisha Blood Center, my lords.
Odisha?
Blood Center, it's a Odisha Blood Bank, my lords, under MKCG Medical Center.
Okay.
Page 16, lords, may kindly see, my lords.
Just what is your prayer for enhancement of retirement age?
Only I am bringing to a lordship two letters. Page 16, lords, may kindly see.
Page 16.
Lords, annexure 2.
How is it? Why is it come to our court?
It's Honorable Justice.
Oh, memorial.
Since I am retiring on Sunday, my lord,
Okay,
that is the
all right.
my lord, page 16, lords,
Hari
may kindly
Krishna
see.
Sahu laboratory technician letter from service on his
36, my lords. On Sunday, I am going to retire, my lords. In the meantime, I am a contractual employee, my lords, and I have also filed a case of regularization that is pending. Now, my lords, government has come out with a decision, my lords, annexure 4, page 22, lords, may kindly see. I may kindly permit you to place.
Yes, please.
The following a committee has been constituted. A committee is hereby constituted for recommending the age of employees up to which his or her contractual service can be continued and principle for extension of contractual service of selected cases beyond this age of persons engaged on contractual basis under different societies or organizations under Health and Family Welfare Department. I am also coming under Health and Family Welfare. A committee has been constituted.
What is the meaning of this? Principles for extension of contractual service of selected cases beyond this age?
Yes, after 60 minutes. Since
So that is under consideration.
Yes, and page
And the date has been fixed, my lord, on 26th.
24, let's may kindly see.
26th month Aji.
Yes, page 24. Let's Annexure 6. Let's this communication has been made to all members.
कौन এটা देखिए कौन है जिनसे
Let's see.
Can we continue?
May permit to place, let's see. This meeting is scheduled to be fixed for today, let's 26/6 for submission of reports of the committee members. If your lordship will kindly direct the London State Council and matter will be kept urgent to day after tomorrow, so that my London State Council can.
If any decision has been taken, my lord, also.
I am serving 2 copies also.
What will happen is, supposing the decision is adverse, then he has to challenge that decision.
Challenge that.
But that would be a policy decision.
But even if, my lord, the policy decision will be taken with respect to.
Yeah, but he
enforcement
can
of
challenge it. He can challenge it.
Now, with
That will affect him directly.
but my lord, that policy decision, even if it is in positive way, my lord, that will be always prospective in.
Otherwise, I will go on 30th my lord, on Sunday because that is.
Yeah, why prospective? They are continuing. Their cases will be considered.
But even if my lord, that decision will be
Age
taken,
of the employee, age of the candidate, no, age of the employee, up to which his contractual service can be continued.
my lord, I am conscious about that particular Annex 6, my lord. Because a decision, a particular decision is required to be taken at the level of the committee, taking into consideration various factors.
No, not decision actually. They will make a recommendation.
That
Government is to
decision, my
consider.
lord, they will form a recommendation and they will recommend it to the competent authority for enhancement by taking a policy decision. And subsequently a decision will be taken. My lord, that issue with respect to enhancement of the age and fixing a particular cut of date and prospective in nature. On 28/6/2014, my lord, when in respect of the government employees, the age was enhanced, retirement age was enhanced from 58 to 60. Cases were filed. So it was before the London Tribunal, thereafter before the Honorable High Court, and thereafter before the Honorable Supreme Court, where it has been held that, my lord, 28/6/2014 is the appropriate date, and there is no illegality or on the unjustifiedness, my lord, with respect to fixing a cut of date. And the decision, once it is taken, it can only have the prospective. So, my lord, but under any circumstance,
No, but
26.
that decision of the government affected the existing employees. It affected the existing employees.
Implemented in respect of the existing employees.
I remember when I was in the Legal Services Authority, my PA, he was due to retire after 4 days. He was extended by 2 years.
Well, that was the ground for challenge before the Honorable Court.
But that did not find favor with this court.
Yes. Because no person who had already attained that particular age of retirement prior to that.
No, it will not be reopened. But somebody who is continuing.
Yes, obviously, my lord, that will be.
So now, if the government or this committee takes a decision,
is going to be taken.
It's called to be done, and very fairly has come to the very rightly has come to the court.
Yes.
Now, at this stage, if it doesn't come,
Because I have approached the authority, they say since there is a committee recommendation, when there will be no communication, so
I am just wondering if a positive decision is taken. Well and good.
Yes, sir.
You will withdraw this. You will withdraw this.
then I don't have any claim. Only I am serving 2 extra copies.
Yes.
It is ଦରକାର ନାହିଁ ତାଙ୍କର କପି ଦରକାର ନା ନେବେ କପି
I'm actually LMS.
ହଁ LMS ନଉଛନ୍ତି ନା ଆଉ ସେଥିପାଇଁ ଆଉ ସେମାନେ they are not it is stated at the bar that the committee formed to consider the question of committee constituted to recommend the age of the employees up to which their contractual service can be continued and the principles for extension of contractual service of selected cases beyond this age of persons engaged on contractual basis under different societies/organizations under the Health and Family Welfare Department is scheduled to meet tomorrow. Stop. Today. Scheduled to meet today. List this matter after tomorrow.
Yes.
Learned State Council shall apprise the court as to the decision taken in such meeting. Yes.
I have served 1 copy also.
ଦରକାର ନାହିଁ ସେବାରେ LMS ନଉଛନ୍ତି ଆଜିକାଲି ଆଉ ନଉନାହାନ୍ତି କପି ନଉନାହାନ୍ତି.
Lord friend said I
This matter, my lord, sir. My part of the argument was over. And my learned friend, my lord, Mr. Patnaik.
Last time you were not there, Mr. Patnaik.
Yes, sir. No. Last time.
Last time ନଥିଲି ସେ last order ଆପଣ
Last date no.
ସେଇଥିପାଇଁ ତାକୁ ଆର୍ଜନ କରାଗଲା ଦେଖିଲେ ହାର୍ଡ ଫାଇଲ ରେ last order ଟା it has not been scanned in my system but it is there. I remember you were not there, that is why I urged.
I'm sorry.
ଆପଣ ଟିକେ ଛାଡି ଦଉନାହାନ୍ତି ଆଜ୍ଞା ତାକୁ sir ସେ ଦିଟା ଜାଗାରେ at least I am requesting the bar please leave those 2 chairs like Justice PC Naik used to do. Mr. Naik, you remember 2 arguing counsel chair
On 19/6, man.
ହଁ There is no appearance from the side of the managing committee.
Yes, madam.
You were supposed to produce the forms.
Yes.
Forms.
Record.
Renewal recognition form.
Yes, yes.
I would allow this deputation education duty, examination duty.
ଆଉ ଗୋଟେ ହେଲା ସେ ଯୋଉ CHSC କି ଦେଇଛନ୍ତି staff
ସେଟା ତ ହେଲା ଏଇ ଦେଖା Mr. B.K. Patnaik land council appearing for the bill. So the management is committee is required to produce the said form. So form for renewal of recognition. Okay?
Because as I was absent and
No, previous that जोटा आपण थिले ता आपण आगरे ऑर्डर पास करा जी आपण आगरे पास करा जी आपण कहितले प्रोड्यूस करियो Mr. Kora has drawn attention of this court to the admission made by the management before the director. The name of the petitioner was included in the list of staff sent for renewal of recognition to the CHSC in the year 1988-89. This court would like to peruse said renewal of a recognition form. Here goto katha. Taparela, they were deputed to examination duty in 1989-99. So that is why you were directed to produce the document relating to deputation of staff for examination duty for the aforementioned period.
my lords, I do not know exactly how to express my sorrow because I went through my lord's order dated 19/3/24 where my lords had directed produce the records.
Sir, 19/3/24 ପରେ sir 19/3/24 କଥା କହୁଛନ୍ତି ତାପରେ ଦେଖନ୍ତୁ ତାପରେ 23/4 7/5 14/5 15/5 ପାଞ୍ଚଟା ଡେଟ୍ ହେଲାଣି.
My lords had directed and I have brought all the records in pursuance to the order dated 19/3/24.
These two records are there.
Yes, yes. Do not mind lords.
ସେଟା ତ ଦରକାର ସେଟା ସ୍ପେସିଫିକ ଅର୍ଡର ହେଇଛି.
Yes, yes, my lord, I
Specifically, sir, counter ରେ ବି କହିଛନ୍ତି.
ହଁ.
They have helped me out. Last time we ଦେଖିଥିଲି sir at page 64.
yes, my lords. Wow.
So I'm only humbly praying, your lordship may close the hearing today. Let my learned friend produce or whatever records.
One opportunity will be given.
What records he has to produce, let him produce by
I'll call it next Wednesday. In the meantime, let him produce.
Yes, yes, man.
close कर दिया.
Hello, Mr. Kora. He is appearing for the managing committee. He may be misunderstood also.
I'm not objecting to his production of records. So whatever
I have given sufficient opportunity and he's saying that in the open court.
Well, so, sorry, I have brought all the records which I was under the impression that
These records were there earlier also. You had produced it. I said this court would like to see,
yes,
because it is his claim that his name was included in the renewal recognition
yes,
form.
yes, man, whatever you want, I must produce.
You take a copy of this order.
Yes, man, that I claim.
ସେଇଟାକୁ ଲେଖିଛନ୍ତି para number 6.
Okay?
Sorry, my lord. I was also entrusted with the responsibility, my lord. I was also directed to produce the file of the appeal file of 995.
So that appeal. Huh?
995. My lord, because that was an year old, my lord. There also, my lord, in paragraph number 6, the lords were referred to that documents were produced before the director. So the lordship wanted to know
The entire original file.
on in the original file. And I undertake that this will be filed by the.
But I will not grant further time beyond Wednesday.
My lord, I have also told them, my lord, they are actually they could not trace it, my lord, because it is a 1995 file.
ये ସେଇଥିପାଇଁ ତ ମ୍ୟାନେଜିଂ କମିଟି ଯଦି ବାହାର କରିଦେଲେ ଏକା କଥା ନା. ପ୍ରତ୍ୟେକ ବର୍ଷ ଯୋଉ renewal of recognition ଯୋଉ form ରେ list of employees ମାନଙ୍କ ଇଏରେ ତାଙ୍କ ନାଁ ଥିବା ଦରକାର ବୋଲି ସେ କହୁଛନ୍ତି. Let us find out. And Mr. Patnaik, from 89 to 99, they claim that they were also sent for examination duty.
Yes,
So the deputation order that
yes.
So bring that. All right. Sri B.K. Patnaik, Learned Counsel appearing for the managing committee, requests for a short adjournment to comply with the order dated, comply with the directions contained in order dated 15/5/2024. Sri Kora opposes the prayer for adjournment on the ground that several opportunities have been granted for the purpose. Stop. Learned State Council also wants a short adjournment to produce the original file before the director in appeal.
In appeal.
Considering how this being a case of the year 2009, matter is adjourned. As last chance. Last chance is granted to the state as well as the managing committee to produce the documents/records as directed earlier. Stop. It is made clear that no further adjournment shall be granted. I understand your anxiety, Mr. Kora, but the thing is that these documents would be helpful for the court to pronounce a judgment.
Again.
So if there's an I got a week time. I made it clear that no further adjournment shall be done.
I will produce record in person to the order.
Order dated 15/2024. You let a copy of the order dated 15/5/2024 be handed over to Sri Patnaik for compliance.
Yes, yes, not good.
3 copy will go.
Lordship, are calling it on the third.
No, on 27th, on 26th. As is 26th. 3rd July.
Obliged. 3 July.
Yes.
13.
Item 13, my lord, kindly pass over the matter.
Yes, please.
Item 13, my lord, kindly pass over the matter.
Pass over.
Yes,
All right.
Item number 14.
Item 14. You are appealing. Item 14.
Yes, please.
The pattern matter.
Yes. It's a particular. In fact, I had appeared once in this case, but my name doesn't appear.
Oh, well,
No, Lordship, I will not take much of a Lordship's time. It is with regard to my lord. The petitioner.
Sir, I have all the time in the world. You can take as much time you want. There is no embargo in time in this court.
I will not make others to wait for this matter. That's the reason. Well, I was not considered to be an Anganwadi worker on the ground of out of the service area. There was an advertisement, and on that basis, we applied. I was in number 2. Number 1 was found to be disqualified, and opposite part number 7, he was found to be placed below me, but she was given appointment. I was denied on the ground of out of service area. That is the case,
You filed appeal.
My appeal was filed.
Appeal was rejected.
Was rejected. Then I have come to your Lordship. Now, the only point for consideration, here is when the residence certificate was issued under the Miscellaneous Certificate Rules 1984, that having not been challenged, that having attained the finalities till date not challenged, could a survey report of a lady who happens to be the mother-in-law of the opposite part number 7, could on that basis, she should be given preference to me. That is sole point for consideration. And the state in the counter, Lordship may kindly see paragraph 11 of the state's counter.
Paragraph 11 of the state's counter.
Yes.
State.
Internal page 5 of the counter.
State is opposite part number 4.
Now this is the
You read that in the instant case, though?
Yes.
Yes.
Opposite part number 4.
Yes.
That in the instant case, both the petitioner and the opposite part number 7 belong to the same Anganwadi center area, and the petitioner has admittedly secured more points than the opposite part number 7. However, the opposite part number 7 was selected for the post of Anganwadi worker since the name of the petitioner did not find place in the aforesaid survey conducted by the Anganwadi helper identifying the persons residing in the said center area as on that day. And Lordship will see my writ application, paragraph 8B at page 11.
Yes.
That so far as the service report basing upon which the candidature of the applicant has been rejected by a selection committee, as well as the additional district magistrate is concerned, the said survey report has no existence in the eye of law. Moreover, the said survey report has been prepared by the mother-in-law of the opposite part number 7, namely Mayavati Gibila, who was then working as a helper of the counterpart to Anganwadi center. This has not been refuted by anybody. Admitted. Now, my lord, even if supposing there is a report, would the report override the certificate issued under the aspect? Well, I'll place one judgment and conclude my argument. The judgment of this Honorable Court of Honorable Justice B.R. Sarangi. It's reported in my lord,
118 to 1014 CLT page 70.
Yes.
Lordship may kindly come to paragraph 5. The two paragraphs are important, 5 and 7. The matter was heard, Lordship, what is that? The matter was heard and the judgment was reserved on 21st of November 2013. But in course of dictating the judgment, doubt arose in the mind of the court that whether the residential certificate granted by the Tahsildar has been cancelled in the meanwhile by following the provisions contained in the Miscellaneous Provisions Act, or any appeal has been preferred by the opposite part number 5 against the same or by any of the persons. Therefore, the matter was listed on the board under the heading to be mentioned on 5th of December 2013. On query being made, it has been brought to the notice of the court that the residential certificate granted by the Tahsildar by the Annexer 1 neither has been challenged by the authority nor by the candidate who participated in the selection process of the Anganwadi worker, nor by any other person. Therefore, the said certificate remains valid until and unless the same is altered by approaching the appropriate forum. In view of that, if the residential certificate granted by the competent authority is wholly justified, on that basis the selection process has been held and the petitioner has been selected securing higher percentage of mark. Therefore, the contention raised by the opposite part number 4 cannot render petitioner disqualified for consideration for engagement of Anganwadi workers. Then para 7, my lord. The claim for engagement of the petitioner as Anganwadi worker is solely based on the residential certificate granted by the competent authority, namely the Tahsildar Baharpal. The said certificate issued by the Tahsildar has neither been challenged by the opposite party nor by the authority by preferring appeal before the appropriate forum under the Miscellaneous Provisions Act as provided in the relevant provision statute. Therefore, the certificate which has been granted by the Tahsildar after causing an inquiry under the Annexure 1 is conclusive proof of the fact that the petitioner belongs to Anganwadi Center area in question and is otherwise eligible to make an application in view of the guidelines issued by the government. This concludes, my lord. And now, Lordship will see annexure where I have filed, my lord, the residential certificate. My lord, at page 18.
Yes.
This is to certify the residence certificate that Anusuya Biswal, wife of so-and-so, is the native of the district Suvarnapur in the state of Orissa, and he finally her family reside in the village town Kodrapal, PS so-and-so, Tahsil Bir Bharat. This has not been toppled. Apart from this pillar, there are other documents I have filed with regard to my name appearing in the voter list, my entire in-laws family's name appearing in the voter list. But if all these documents are there, could a survey report prepared by the mother-in-law of the opposite part number 1, well, if pitted against that report is pitted against these statutory documents, will that prevail? On that basis, well, my appeal has been rejected. That's all.
Yes. Lordship, just to find the ground for the what the run ADM has
Annexure 5.
Annexure 5, page, my lord, 48. Had gone through the entire case record, the CDP Virmaraspur by letter number such and such has submitted related documents like copy of the application of the applicant and respondent along with the resident certificates, comparative statement of marks and survey list. It reveals that the applicant and respondent had applied for the post of Anganwadi worker of Kordapal to Anganwadi Center. The applicant has secured 61.9 points and the respondent has 53.13 points. Both the applicants and respondent have been issued with resident certificate bearing number such and such respectively. They were resident of village Kordapal. They used the survey list of Kordapal to Anganwadi Center submitted by appellant and also by the CDPO. It is found that serial number 10, 11 and 12, name of Sri Tiki Charan Biswal, Sumitra Biswal and Tuni Biswal find place respectively. Tiki Charan Biswal is the father-in-law of the appellant. Neither the name of the appellant nor the name of her husband Sukumar Biswal is available in the survey list of Kordapal to Anganwadi Center. The name of respondent finds place at serial number 41 of the survey list. Her husband Sri Rajendra Kumar Gibila and son Swastik Kumar Gibila have also been enlisted in the survey list by serial number 40 and 42 respectively.
25-2007.
Circular dated 1/3/2008, my lord.
1/3?
1/3/2008.
କେତେ ପେଜରେ ଅଛି?
Page 54 ରେ ଅଛି.
1/3/2008, yes.
Yes. From CN Behra, additional secretary to government to the CDPO, clarification on selection of or engagement of Anganwadi worker. Sir, madam, with reference to the above noted subject circular, the IDM has rightly rejected the
Next. Yes, doctor, next.
residential certificate issued by the Tahsildar could be entertained. I am coming to this, my lord. Lordship, then kind of a glance to my counter affidavit, my lord.
Copy number 7?
My lord.
Yes.
Paragraph 6 of my counter affidavit, my lord. In reply to averments made in this petition, it submitted that the petitioner is not residing within the service of Anganwadi center. Rather, she is staying at Sambalpur and her son is studying at Dayanand Public School, Dhanupalli, Sambalpur, staying at Gobindtala, Ward number 2, Dhanupalli, Sambalpur, which is evident from the school admission register as obtained by the answering opposite parties under the Right to Information Act. Furthermore, it is submitted here that the name of the son of the petitioner with the name of the petitioner and her husband name stands reflected in the survey list of Maruti Nagar, Gobindtala, Sambalpur, which clearly shows that the petitioner was never residing with the service area of Kordapal to Anganwadi center, and hence accordingly the my lord. Lordship, the can be to annexure B/2, my lord. Page 31. The internal page 31, my lord. Lordship. Enclosure with the information short, my lord. Then lordship kindly turn to that page 33. Running serial number 73/156. Date of admission 7/4/14. Name Tanmay Biswal. Parents name Sukumar Biswal and Ananya Biswal. Present petitioner. Permanent resident Gobindtala, Ward number 2, Dhanupalli. And moreover, my lord, then lordship kindly have a glance to annexure C/2, page 35, turning page 84. The information residing that from CDPO office that the present petitioner, their name are reflected in the survey register of the Gobindtala Anganwadi center, my lord. And my lord, the decision, my lord, I am relying upon a decision that is in the case of Sunjukta Devi. Last occasion I have supplied para 11 of the judgment.
Judgment. Judgment.
As per conditions stipulated in the advertisement clause 1, it was specifically mentioned that a candidate must be a permanent resident of Anganwadi center area. Clause 3 prescribed qualification of such advertisement. Clause 5 of the said advertisement prescribes that physical entry such and such. That my lord, this so that when my submission is that my learned senior is emphasizing on the residence certificate. Residence certificate is for a wider purpose, but for the consideration of the post of Anganwadi worker, the person is to be in the specified Anganwadi center area, must be a resident of the Anganwadi center area. But the guideline dated 1/2008 submitted. Nowhere the petitioner is residing in the advertised Anganwadi center area. That's why she is not been selected for the post of Anganwadi center.
Yes. We'll come to your affidavit, counter affidavit.
Yes.
Paragraph
11.
Paragraph 11.
Yes, I will. With respect to the place of residence of both petitioner as well as the opposite party, that is not in dispute. Here it is not a case relating to Anganwadi center. It is relating to mini Anganwadi center. And for mini Anganwadi center, 25/2007 is mutatis mutandis applicable, but they have a separate guideline. And my lord, that says the relaxation, but it is available with the Anganwadi centers with respect to the village or nearby village, other things matter. That is not available with respect to mini Anganwadi center, where a person must have to be of that particular service area. So residential certificate, my lord, that has been issued and that is not in dispute with respect to residence. The residence, the entire dispute rests, my lord, the document what they have annexed, and we are also saying that that is correct. If a lordship will come to Annex 3, page number 19 of the writ petition,
Yes.
it is with respect to out of service area in respect of the last person, the petitioner in this case. So it is not that she is not a resident, we are disputing that resident status. When there was a verification with respect to the service area, at that particular point of time, my lord, they found that this particular petitioner is not within that, residing within that service area. Now, that has not been disputed, excepting one submission, my lord, that has been prepared by a particular person who is motivated or some kind of manner. But other than that, that is not in respect of this particular petitioner. That if a lordship will come to that particular report, that report is comprising of the entire, the whole persons who are actually residing there within that service area. And it is available, my lord. Counter submitted by the opposite partner of 4. It starts with Annex C by 4, my lord, it starts with page number 17. And with page number 25. So that is not with respect to any particular person. That is with respect to the total persons who are residing within that service area. And there they found that the petitioner is not available. So that is the only point. And here, my lord, the decision, what it has been relied upon, I entirely agree with the same. But that is with respect to the Anganwadi center. And in the other case also, already I have tested, my lord, the difference between the two guidelines. There, it has been made mandatory in respect of the mini Anganwadi center that she must be within that service area. So that is the point what it has been taken into consideration, and both selection committee as well as the operator.
Hearing concluded, judgment is.
My lord, only one time is supplement, my lord.
Don't. You can't, yes.
Well, I do not know how to respond well to what language to respond. Lordship just sees page 49, the impugned order. But this is a statutory proceeding. Can, my lord, any lawyer develop or improve the case otherwise than what the impugned order says? Had it been some other case, this is different. At page 49 of the impugned order, the order speaks of the notification. Which notification your lordship saw just now at page 54 of that book, my lord. That notification says the notification based upon which my appeal has been rejected. That notification says residential certificate issued by the Tahsildar should be entertained. I do not know in what way I am allowed to counter his argument other than showing this to your lordship. This is purely preposterous as submission.
Hearing concluded, judgment is.
My lord, one line, my lord. Part my learned senior submitted that the survey report was prepared by the mother-in-law of the present appeal number 7. There was never a ground in appeal also.
Yeah, it is in the writ application.
Yes, no, it is in the writ application. It was never a ground in appeal, my lord.
Item 15.
Same problem, JJ. Search for the record that your lordship wanted to see, but they could not trace it out because of 2012.
I said, if the previous order is not complied, the director must appear in person. He has not appeared?
No, he has not appeared.
I think in the GRCO, unless it is 30 years, they cannot destroy it.
Yes, that is a fact.
It is only 12 years. How can they say not traceable?
No, they have not said not traceable. They have not found it so far.
Is this matter day after tomorrow? The Director Higher Education, Odisha.
Secondary,
Director Secondary Education, Odisha shall appear in person and file an affidavit as to why the previous order of this court was not complied with. Further, he shall produce the relevant record as directed earlier.
Yes.
Item number 16.
No, please, for the petitioner chief. The petition is the engages Anganwadi worker
And in the meantime, let's see, the ADM, Annex 3, let's see, ADM has rejected the and cancelled the appointment of the petitioner and stated there in the order sheet, let's see, in last para, the further CDPO has submitted the before the sub-collector appeal number so and so in 22 of the
କୋଉଠୁ ଆଜ୍ଞା ପଢୁଛନ୍ତି କୋଉ
चलो अच्छे भी this case
ନା କୋଉ ପେଜରୁ ପଢୁଛନ୍ତି
ଅଛି unless ଚलो ଅଛି 3 ଅଛି page ଅଛି 15 ଅଛି the CDP submitted CDP that only that girl lordship the cancellation of appointment order by the ADM lordship. The CDP submitted report by
ଫ୍ୟାକ୍ଟ କଣ ଟିକେ କୁହନ୍ତୁ ନହେଲେ ମନେ ପଡିବନି ଫ୍ୟାକ୍ଟ କଣ
I'm coming to fact lordship. Also petition one advertisement
everything will be clear if the entire order set will be
no lordship. The CDP has published advertisement lordship under 770
with the lordship's permission before proceeding with this case. If it has not been amended in the meantime, well, the order under Annex 3 is actually under charge. And that has been issued by the appellate authority. And he is not a party in this case.
who is not a party
ADM is not
need not be made a party need not be made a party
so also
It is his order, my lord.
so why should he be made a party it is statutory jurisdiction
My lord, I don't dispute that, my lord, but my lord, in this case, under these type of cases, my lord,
normally they are made parties he can orally make
the ADM is not the authority, operator authority, as because the guideline is clear says suppletor of the appellate authority. But it is the order passed by the ADM lordship, it is illegal and ignorance lordship. Lordship fact is that lordship in this case lordship, the suppletor sorry, HDPO Satyavadi has published an advertisement and
CDPO
Satyavadi lordship. And published advertisement dated 770 dated 30/2009 and required as the Anganwadi worker under the all case Dubai center. 8 number of applicant is filed the application before the suppletor. Last date was fixed on 15/2010. Application received at last date received date is 15/2010. And the petitioner the applicant and 8 number of applicant has applied for the post of the Anganwadi worker. The petitioner one the applicant lordship. And after verify the document and she has secured highest mark and get the selection as per the advertisement 770 dated 30/2009. So in the meantime, another advertisement has wrongly published by the CDPO Satyavadi 4/27 on dated 16/2010 and the face application is received and that has been correct in which that is the order also and that face and that has been rectified and that which also and that has been declared that is a wrong advertisement is published and it has been read and correctly and that the opposite party one challenge this order achieved and the advertisement and stated that the applicant has not filed the application in the due date and he has filed the second advertisement and that is incorrect. That is absolutely incorrect lordship. That is admitted in the CDP also admitted lordship. Lordship Annex 1 page lordship page 8 lordship by read application lordship. And that is been mentioned in the report of the in the report of CDP Satyavadi submitted that no face application has been received in respect to the advertisement made in October 2010. She has further submitted that the selection will be made on the basis of the advertisement 30/2010. Thus, the last date of receiving application of 15/2010 and the date of scrutiny was on 16/2010. The CDP Satyavadi has entertained applications received in due date 15/2010. And the merit list will be prepared and as per the result of scrutiny held on 16/2010. And by the way, the apprehension of Srimati Sonopura Tripathi, opposite number 1 in this read episode, the present applicant that she will be deprived of claim does not arise. And in page now that has been mentioned in the software, the sole pair of the applicant is also same. So she has no objection if the scrutiny date is taken in sure like the user does. And the opposite party has not been objection, they have not filed any objection that taken sure like that thus where the objection date was fixed on sure like the user. There is not objection that time. And the application received on the applications received within 15 days are entertained for the application of the merit list. Under the above situation, I do not find the pair of the applicant will be considered at the time of selection of the worker as per your own claim. Hence, the case is disposed of. And that order has been challenged by the open owner before the ADM Puri. And ADM Puri has mentioned in the order sheet, page 17 or see. And he has mentioned further the page 17 also, because attention page 17. Further, the CDPO has admitted before the sub-collector in appeal number 22 of 2010 in writing file letter number 1415 dated March 2012 that selection will be made on the basis of advertisement made in 30/2009 and the only application of the applicant has been received and it has been wrongly interpreted by the ADM that order received. And all the so-called and agent filed by the CDPO before the sub-collector and before the ADM, and he has clearly mentioned received and mentioned I have received in the count region that I have filed that document received I filed. Region against open number 1 received. In sub-collector received sub-collector the CDPO submitted the so-called report. It has been mentioned according to only applications received in due date 15/2010 has been received and merit list has been prepared. The apprehension of a sole party, she will be deprived of her claim does not arise. And also same so-called has been filed before the ADM received. And she has paragraph she has mentioned second notice was issued for the purpose of verification of the original certificate, mark sheet and the relevant materials, in which it was mentioned that applications are to be submitted on 30/2010, which has been correct. Accordingly, merit list was prepared out of the application received on 15/2010, which the application of the applicant was also there. So, also my submission was as per the advertisement 770 dated 30/2009, the last date of application received on 15/2010. My application has been received by CDPO in due date 15/2010. I have selected as per the provision of the guideline and I have secured highest mark and I have selected. So it is wrongly advertisement published by the CDPO and that has been that has been correct provision and it is wrongly mentioned and it will read the correctly that has been mentioned at but that in particular that you will see and the my opposite party.
I get your point. I get your point. Yes. Yes, Mr. Patnaik.
Yes.
There was an advertisement on 30/12 or 2009.
Yes.
Last date was 15/2010.
Thus.
The petitioner's application was received by that date.
Yes.
She was selected.
That is the point in dispute, madam.
She was selected, that is what.
She was selected, but whether the application was received before the cut-off date or not, that is the point of dispute, which has been adjudicated by the appellate authority.
Yes. What does the appellate authority say in this regard?
Annex page note 16, gone through the written note of argument.
No.
May I permit it?
Yes.
Gone through the written note of argument filed by the respondent 2. Respondent 2 is CDPO, madam. Yes. In the said written note of argument at para number 5, it has been mentioned that CDPO has submitted report before the sub-collector in appeal number 22 of 2010, and order is at Annex 1, that no fresh application has been received, and the last date of receiving of application was 15/1/2010. From the written note of argument, it is illustrated whether the application of respondent has been received during 15/1/2010 If it is received during 15/1/2010, then the application of respondent will be taken into consideration or otherwise not. Supervisory report of CDPO Satyavadi by letter dated 289, dated 35/2011 reveals that the second notice was issued for detailed verification of original certificates, mark sheet and other relevant papers on 1/2/2010, but by mistake it was mentioned that applications are to be submitted on 30th January 2010, which was subsequently corrected. It appears that the content in the notice issued on 1/2/2010 and 30th January 2010 respectively are totally different. The official acts are always presumed to be correct. The deadline in both the notice and the subject matter are different. Hence, the first notice cannot be corrected by issuance of the second notice. Further, the CDPO has admitted before the subcollect in appeal number 22 of 10 in writing by letter dated 12/4/2010 that selection will be made on the basis of the advertisement made on 30th 12/2009, and the only application of the appellant has been received during the due time, that is on 15/1.
The appellant is the petitioner.
Sony property, that is the respondent by the. Where is the notification issued by the CDPO by number 427 of 18/1/2010? It is seen that the name of Swarnaprabha Tripathi of Arikia Dubaipur Science Place at serial number 1, whereas the name of Puspanjali Malik, the petitioner, my lord, does not find place in the said list. Hence, it is obvious that the name of Puspanjali Malik has been reflected in the subsequent second notice, which is illegal and against the provision of the revised guideline of the government in WCD. Therefore, the selection of Puspanjali Malik as Anganwadi worker in Ali Care Center, my lord, is set aside. So, on this particular factual aspect, my lord, that there are certain act or omission on the part of the CDPO. And that has been taken into consideration, all the documents and submission made by the CDPO. I have also verified that time and again, my lord, the CDPOs during that particular area, my lord, they have changed that and their position has been changed. Sometime it was in charge, sometime regular. And my lord, the statements were taken into consideration which were presented before the competent authorities. And documents were taken into consideration, and thereafter.
Now, where is the document in which that notification where the name of the opposite party finds place, that Puspanjali? Swarnaprabha.
That was the single.
Come to the last page of the.
Yes, sir.
It says,
there is
the notification issued by CDPO word number 18/1/2010. It is seen that the name of Swarnaprabha Tripathi of Olikia Dubaipur finds place at serial number 1, whereas the name of Puspanjali Malik does not find place in the said list. Who was appointed? Puspanjali. I will hear you. Puspanjali Malik was appointed.
Puspanjali Malik got appointment.
How could she get appointment?
My lord, that is why, my lord,
so the records have to be seen. We have the records.
Yes.
Lordship, in this case, Lordship, the CDPO and the senior counsel not denied. Because in first advertisement dated 7/70/2009 and the last date of application received on 15/2010. So neither CDPO nor my senior counsel has denied the dispute because I have applied in first advertisement.
That is the sole point to be decided.
And that Lordship was wrongly interpreted by the ADM Lordship. I have filed the annexure Lordship and the my regent Lordship against the opinion number 1 Lordship. So, page 23, Lordship. And so, what is the show page filed by the CDPO before the suboperator and also ADM? In suboperator, Lordship, she has mentioned because there is English difficulties in English, Lordship. So, I'm sorry, and it is mentioned, Lordship. No fresh application has been received. Accordingly, only applications, because typical error, it has been ADM, Lordship. It has mentioned only application, Lordship. Only applications received in due date and 15/2010 has been entertained and merit list has been prepared, Lordship.
Yes, so you have to show the record. What were the applications received? Yes, what is your stand?
You also come to my counter. Annexure A by 1/A. This is the advertisement. The last date of submission of application was 15/1/2010 and the state of scrutiny is 16/1/2010.
then another letter was issued, unless 1 by B. Page 9 of my counter. ଏତଦ୍ୱାରା ଜଣାଇ ଦିଆଯାଉଛି ଉକ୍ତ କାର୍ଯ୍ୟାଳୟ ନୋଟିସ 326/1/11/2004 ତାରିଖରେ ସ୍ଥଗିତ ଥିବା ମହରା ଗାଁ ଅଙ୍ଗନବାଡି କେନ୍ଦ୍ରର ନିମ୍ନ ସୂଚନା ଅନୁସାରେ କାର୍ଯ୍ୟକାରୀ ଯୋଗ ଏଥିରେ ଲେଖିଲା ଆଳିକିଆ ଗ୍ରାମ ପଞ୍ଚାୟତ ତାର ଏକ୍ସଟେନସନ ଦରଖାସ୍ତ ଗ୍ରହଣର ଶେଷ ତାରିଖ 30/1/2010 ମୂଳ ନକଲ ଯାଞ୍ଚ ହେଲା
29 ଲେଖାଇଛି 30 ତ ଲେଖାଇନି
30 ଲେଖାଇଛି ସେକେଣ୍ଡ ଲାଇନ
ଆଳିକିଆ ଦୁବେ
30/1/2010
ହଁ that was corrected.
No, there two lords what happened. There another letter was issued 1 by C my lord. ସେଥିରେ ଯୋଉ 7 ଜଣ ଆପ୍ଲାଏ କରିଥିଲେ ଦେଇଛନ୍ତି ସେଥିରେ ତା ନାହିଁ ନାହିଁ ସେଥିରେ 1/2/2010 ରେ ଏଟା ଲେଟର ନମ୍ବର 735 ଡେଟ୍ ହେଲା 1/2/2010
yes
ତା ପରେ ଗୋଟେ ଆଉଟ ଆସିଲା ସେଥିରେ ତା ନାଁଟା ଆସିଗଲା ଆମେ 1 by D
my application
ଆପଣ କହିଲେ ମୁଁ କହିଲି
there seems to be a factual dispute. Yes. In one of the notices, the name of Pushpanjali Malik is present. In the other, Pushpanjali Malik is not there.
Same letter, Jordan letter is
no application I have annexed my region I have annexed the application which particular
so how many applications no just a moment how many applications
application
ଆପଣ ସେଇଟା ତ original record
counter government counter 7 ଜଣ
ଏଇ ଯୋଉ ରେକର୍ଡ ଗୁଡାକ ମୁଁ ଦେଖୁଛି ଯୋଉ ତାଙ୍କ ରେଜିଷ୍ଟର ଗୁଡାକ ସେ ରେଜିଷ୍ଟର ଗୁଡାକରେ ଦେଖିଲେ ସେଥିରେ ସେମାନେ ଲେଖୁଛନ୍ତି 8 ଜଣ
including the
ଯୋଉଟା କି subsequently
dispute କରିନା ତ
ଏଇଟାକୁ ଇଏ
come to the rejoinder where
ନା ଆମେ dispute ସର ଗଭର୍ଣ୍ଣମେଣ୍ଟ ଯୋଉଟା ଏଡିଏମ କ ଅର୍ଡରରେ ଯୋଉଟା dispute ହେଇଛି
ହଁ ସେଇଟା ସେ କିନ୍ତୁ କହିଲେ accordingly you CDP will come to running page I think it will be 90 annexure B/3 to the rejoinder B/3 होगा था ना कि से B/3 करछन anyway या भी क्षेत्र से लिखे जो letter of the CDP to the sub collector
yes
directly I am to inform that instead of verification of original certificate on 1/3/2010 by mistake it has been mentioned that the fresh applications are to be submitted on 30/1/2010 which has been corrected and no fresh applications have been received. This is very clear.
Well, that has also been taken into consideration.
Just a moment. So this is the next part of the contract. Accordingly, only applications in plural received in due date 15/2010 has been considered. So we have to find out 15/2010 ଭିତରେ କୋଉ application ଥିଲା କି ନାହିଁ ଆଗର ଥିଲା
ଏଇ କାଉଣ୍ଟର ଦେଇଛନ୍ତି ସର
ସେଇ ଜିନିଷଟିକୁ ସାର୍
ଆପଣ ରେକର୍ଡ ଦେଖିକି କୋଉ
ମୁଁ ସାର୍ ଏଇ ଯୋଉ ରେକର୍ଡଟା ମୁଁ ଦେଖୁଛି ଯୋଉ ସିଲେକ୍ସନ ଲିଷ୍ଟଟା ତାପରେ ଯୋଉ ଜିପି ମହୁରାରେ ଯୋଉଟା ଏମାନଙ୍କର ସବୁ କନସିଡରେସନ ହେଇଛି ସେଠି ସବୁଥିରେ ଏଇଟା 8 ଜଣଙ୍କ ସହିତ ଲେଖା ହେଇଛି ଯୋଉଠି କି ସ୍ୱର୍ଣ୍ଣପ୍ରଭା ତ୍ରିପାଠୀ and ପୁଷ୍ପାଞ୍ଜଳି ମଲ୍ଲିକ 2 ଜଣଙ୍କ ନାଁ ଏଠି ରିଫ୍ଲେକ୍ଟ
ତାହେଲେ
ଏଇ ଡକୁମେଣ୍ଟ ଗୁଡାକ ଯୋଉଟାକୁ କୁହାଯାଇଛି ଏଇ ଡକୁମେଣ୍ଟ ଗୁଡାକୁ ହିଁ ଡିସ୍ପ୍ୟୁଟ କରାଯାଇଛି ଇନ ଦ ଅପିଲେଟ ଅଥରିଟି the name of that petitioner Pushpanjali Malik it was not received prior to 15/1/2010
how do we know that on 15/1 ତାର ତ ଗୋଟେ ଲିଷ୍ଟ ଥିବ ନା କୋଉ ଆମେ ଆପ୍ଲିକେସନ କେତେଟା ପାଇଲି ବୋଲି
yes
ଅରିଜିନାଲ ରେକର୍ଡ ଥିବ ନା
ତ ଅରିଜିନାଲ ରେକର୍ଡରେ ତ ଯୋଉ ରେକର୍ଡଟା ବର୍ତ୍ତମାନ ସେମାନଙ୍କ ପାଖରେ ପ୍ରିଜର୍ଭ ଅଛି ସେଇ ରେକର୍ଡଟା ଦେଖୁଛି
ତାହେଲେ
on the basis of the statement what it has been submitted before the sub collector in the year 2010 by the CDPO.
What does she submit? He says accordingly only applications received in due date 15/2010 will be considered.
ପୁଷ୍ପାଞ୍ଜଳି ସେଥିରେ
ନାହିଁ ବୋଲି ତ କହୁନାହାନ୍ତି କୋଉଠି
ସେଇଟା ମୁଁ ଦେଖୁଛି
applications
ସେଇଟା to that extent that is there.
ପଛରେ ଯୋଡ଼ି ଦିଆ ହେଇଛି ବୋଲି ଗୋଟେ ଆପ୍ଲିକେସନ ଆସୁଛି କିନ୍ତୁ ସେଟା ମାନେ it has to be proved.
ଗୋଟେ ଡେଟ୍ ରେ ଯୋଡ଼େ ଚିଠି ହେଇଛି ଗୋଟେ ସେମ୍ ଲେଟର ନ
I've seen which you have. ଅରିଜିନାଲ ସିପି ଫାଇଲଟା ମଗା ହେଇଥିଲା ଫାଇଲ ଥିବ
ସର ଏକ୍ସଟେନସନ ବି କାହିଁ କରାଗଲା ତାର କିଛି ରିଜନ ନାହିଁ ସବୁବେଳେ ତ ସ୍କୁଟିନ ଡେଟ୍ ତାପରେ ପୁଣି ଏକ୍ସଟେନସନ କରାହବ
ଆପଣ ଦେଖିଲେ will continue.
Sir, ଏଇଟା ମୁଁ next week ରେ ରହୁ କୋଉଟା ଏଇଟା?
Hearing part. The part of dispute
That has ସେଇଟା that has been dealt by
of the case appears to be
yeah,
the date of they appear to be whether the petitioner had submitted application within the due date, that is 15/1/2010. There are contradictory documents showing contradictory documents. Learned State Counsel is requested to peruse the original file and to apprise the court accordingly.
Yes.
Place this matter next week.
Item number 17.
Next week, madam. In this case, I have received a counter affidavit from operative number 5. I want to put rejoinder. I want to put rejoinder.
Place this matter next week as paid for. Rejoinder if any be filed in the meantime.
Item number 18.
18 minutes, the compliance was handed over to my learned friend. He had submitted that he will be taking instruction.
Yes.
Yes, ma'am. Now, please, your lordship. This is not a compliance order, madam. Well, this is a case, first of all, this is a case of contempt. In a contempt, the duty of authority to comply the order of the learning tribunal or court, or else to challenge the same before the hiring forum. Without doing so, my lord, sitting over the order of the tribunal, so your lordship's clarification in your lordship's order, yet passed another order. That is, I am reading out. What is their order? The lordship have a glance. Page 2. Page 2.
Here, just a moment. The respondent of 1, 2, and 3 were to take appropriate action for regulation of the services of the applicant and issue appointment order following the regulation of the government added Southern of the welfare, as has been done in case of similarly situated paramedical staff such as MPHW and वगैरह. अच्छा contempt हमको किन कैसे? Contempt तो chief को बोल दिया क्या? As per the new assignment. The assignment has changed. Single judge contempt.
All contempt matters.
All single judge contempt matters have to be heard by the Honorable Chief Justice.
It is, sir, especially because the
Special assignment is
endorsement data, sir.
Yeah, what about the specially assigned matters? Sithri good assignment, good each assignment list. To buji the no, kali na wa koni. Now clarification is it was done by the Honorable Acting Chief Justice, but subsequently, as per the new assignment, I think there is some endorsement that specially assigned matters will also go back to the roster bench.
Yes.
कौन है जी? हाँ? DN को डकी के पछाड़ दे? ये थी तो हम सुना करते हम छोड़ दो. That is why I said you better file a compliance affidavit.
Yes.
It will be better.
Not only that order which was.
Anyway, let us take it up tomorrow. If it is assigned to this bench,
yes,
then I'll ask you to file a compliance affidavit. Otherwise, it will go. All right, release this matter tomorrow. I want to do. Rajiti Bujiti, huh?
May I please, Lordship?
In portions to advertisement issued under Annexure 1, that is at running page 8.
Yes.
The petitioner applied and she was selected. Annexure 3, running page 13 is the selection. I am placing my lord.
ଆଶା ଚୟନ ନିମନ୍ତେ ଏକ ବୈଠକ ଅନୁଷ୍ଠିତ ହୋଇଥିଲା ଏଥିରେ ସୁକିନ୍ଦା ଗ୍ରାମର ସରପଞ୍ଚ ଅଧ୍ୟକ୍ଷତା କରିଥିଲେ ଗ୍ରାମର
The selection committee selected. The petitioner worked for 10 months. All of a sudden, kindly have a glance annexure 4 running page 15 next to his my lord. Subject to Arati Shah, the ANM of Sukinda Sub-Center. Subject dismissal letter regarding Kapita Rani Barik, Asa Barik Sai. With subject cited above, I am to inform you that Srimati Kapita Rani Barik, Asa Barik Sahi, village Sukinda is dismissed from her work from 27/11/2018. So further any payment will not be paid from this date, and the pending voucher for the work is to be deposited to the office for payment without any show cause, nothing else. All of a sudden dismiss the petitioner. Challenging that this order, the petitioner is before this honorable court.
Yes.
But instructions have been received for the reason that it was under the old procedure. So it was given a go by, so let me file the affidavit.
Well, this is a case of the year 2008.
How can you justify this order? No show cause notice, nothing. Principles of natural justice.
Promissory estoppel. They have issued advertisement and they have selected. They are saying that the old procedure they have selected.
No, this court, the coordinate bench directed you to take proper instruction regarding the guidelines which was followed at the time of selection process.
Yes.
Yes.
Now,
So what is your instruction?
is this much.
What is the instruction?
The selection committee adopted the old procedure for selection of to the post of ASA, and accordingly objections raised by all the other applicants. After receipt of objections from different sources, one inquiry has been conducted by the district administration, and the inquiry officer, that is ADPHO FW Jajpur, detected the irregularities made by the selection committee. Accordingly, medical officer in charge CHC Sukinda issued the dismissal order by the impugned order, Annex 4 to the petition. Going through the inquiry report, the dismissal order was issued as the engagement was treated irregular, and an irregular appointment needs no show cause or prior notice, as the engagement itself declared invalid. The appointment to any post, then he has justified.
How the principles of natural justice will be given a go by? You appoint him. You appoint him and then say, I am irregularly appointed.
That should not have occurred.
See how. No, there seems to be some irregularity. When you come to the appointment order, engagement order, say third line de एथिरे सुकिंदा ग्रामर पूरा लंबा गैप रही गला तापर हला सरपंच अध्यक्षता करथिले मैं से नाटा पछरे जोडा हो बोली छाड़ दिया गला तापर आशा चयन निमित्ते पुनी गुडा लंबा गैप ग्रामर एक जन प्रार्थी आवेदन करथिले को ग्रामर अपन इट इज लेफ्ट टू योर इमेजिनेशन तापर कविता बारिक को एई ग्रामर आशा चयन करा जायतिला सेटा से गैप रे पर पूरा हिची एतरी बैठक रे थिला समस्त मेंबर मानकर अनुमोदन निया जाई कविता बारिक को एई ग्रामर आशा भावे चयन करा जायतिला तो फाइल एन एफिडेविट
Yes.
Learned State Council submits that he is ready with the instructions and requires some time to file the affidavit. Let's just reply affidavit. Let's just matter.
Otherwise, if your lordship pleases, may I submit that the collector may be directed to, after hearing the parties, let him come.
Then I will set aside. I'll set aside. I'll record your submission that because of this reason,
yes,
the person was dismissed, which does not conform to the principles of natural justice, so it cannot be sustained, it will be set aside. And if there is any irregularity, it is for the collector to inquire and consider after giving opportunity of hearing to all concerned.
Since my 2018, I am before this honorable. Mate reinstate करके तो hearing करंतु.
Reinstate करी आपनकर interim order कौन हिची?
किछि interim order न था.
Interim order हेनी अब की बोली. 2018 interim order कौन हितली सेटा कौन order हिता ना. बता ना only it can be set aside. So you file an affidavit.
As your lordship.
कौन लिखा? That he is ready with. Affidavit. Does this matter? Kibe?
2 weeks after.
2 weeks after कौन? वो तो कौन डेट करो? या पर week या पर week
10th July.
10 July. Does this matter on 10 July? Affidavit if any be filed in the meantime.
Item 20.
May I please note? Lordship, last order 2 to 23, Lordship directed for production of the original records, Lordship.
necessary to peruse the original file related to selection of Anganwadi worker, Vishwanathpur Mini Anganwadi Center.
Yes.
That was passed in February 2023
Yes. Oh, yeah.
by me when during my last assignment.
Yes.
What happened?
Sir,
ବର୍ଷେ 4 ମାସ ହେଲାଣି ଆସିନି ରେକର୍ଡ ଆଜ୍ଞା।
ଆଉ ଗୋଟାଏ ଚାନ୍ସ ଦିଅନ୍ତୁ, ଲେଟ୍ ମି ସି।
ସେ ନିଜେ ନେଇକି ଆସନ୍ତୁ ରେକର୍ଡ, କୋର୍ଟ ଦିଅନ୍ତୁ ସେ। Learned State Council requests for an adjournment. Requests for some time to comply with the order dated 2/2/2023. Last chance is granted to the State Council for the above purpose. List this matter on 10 July. It is made clear that no further adjournment shall be granted.
Item 21.
My lord. The order of disengagement under Annexure 9 without following the due process of law and even if without issuing a notice that has been passed, let the petitioner appointed as a Shiksha Sahayak, while she was continuing as such, my lord, remain absent, my lord, on the ground that, my lord, the maternity leave was taken. Thereafter, she was ill and filed application for CL. That was duly forwarded. But the same was not when she joined, my lord, after medically fit. The documents were not submitted before the higher authority. Annexure 7, page 30.
Unauthorized absence from 19/6/2015 to 21/7/2019.
In my lord, two phase, all the applications were accepted and forwarded, but those documents were not submitted before the higher authority. Annexure 7. Annexure 7, it was called for that you produce all the documents. It was sent by the DPC to the BO. And the same date was fixed on 10/12/2019. The petitioner also present, produced the document. The BO also produced the document. Thereafter, my lord, nothing. Annexure 9 was passed, saying that on hearing order number so dated 17/12/2019 of the DO district project coordinator.
In pursuance to the hearing order number 8. What is the meaning of hearing order?
My lord, I don't know, my lord, that is no such order. That has not been communicated to me. I am not aware about what is the order.
2010 Srimati Saurabhala Chwal Singh, who was joined as junior teacher contractual hospital Shiksha Sahayak, is hereby disengaged from the post of junior teacher with immediate as she has remained unauthorized absent for a period of longer period from without adhering the government instruction guidelines and deviating the rules. Yes, what is your counter?
Counter paragraph 5. That unauthorized absence. After she availed the maternity leave, she remained unauthorized.
She joined on 23/6/2014. She applied for maternity leave from 13/10/2014 to 13/4/2015. Mas
copy of the counter.
After she joined on it and continued up to it. Without submitting leave. So the question is, they admit that you had submitted maternity leave from 13/10/2014 to 13/4/2015.
Yes.
Man, say you 6 months.
My lord.
Then you joined on 13/4/2015. From 29/4/2015, they claim that you have been unauthorized absent. You claim to have submitted some
the documents and it has been duly forwarded. That's why, my lord, Annexure 6 and 7, 6 series, page 26. The BO also forwarded the same to the DO. Thereafter, Annexure 7 was issued by the DPC.
No, Annexure 6 is just the
forwarding.
No, not the forwarding.
Since I submitted my
that is the representation.
My lord.
After your joining in 2019.
My lord.
But before availing leave, did you submit any application?
My lord. All this, my lord, Annexure 5 series, my lord, 2 series, I have given, all has been forwarded. And that's why, my lord, Annexure 7 was passed. The page 30, Annexure 7 was passed by the DPC, saying that to the BO as well as the petitioner, you produce the relevant documents and the acknowledgement when you produce all these documents. The date was fixed on 10/12/2019.
Yes, Mr. Das.
Yes.
This bunch of applications all have been received, at least by the headmaster. He has given a lot of several applications. All of them have the endorsement of receipt of somebody, either the headmaster or copy forwarded to BEO will লেখা আছে এতে কিন্তু ডেট নাই এইসব থিওরি তো তার ডেট কাই কোন ফরওয়ার্ড করলে ডেট পেলেনি কিভাবে ডকুমেন্ট তৈরি করার গোটে ভারি ইয়ে তো ডেট পেটটা ছাড়িয়ে যায় দেখুন রিসিভ করার ডেট দেলো যেদিন পঠাইলে সেদিন ডেটটা দেবো নিশ্চয় হ্যাঁ very difficult to believe this. These are all created documents.
On Annexure 7, the Deputy Director, the VO.
So have you taken specific stand that you have not received these documents?
No.
You have not taken that stand?
So that was not brought to the.
Let us see what is the headmaster say. What is the counter of the headmaster?
The BO has shown.
Yeah, headmaster को तो दिया है ना, and the headmaster has forwarded it to the block education officer. If he doesn't say so, then it will be very difficult for this court to believe. Voilà, sir.
The headmaster only says that after Annexure 6, that we forwarded all the documents.
ये बिल्कुल लिखी ना थी इसी विषय.
My learned friend says that he has no copy of the counter
of the government. I have not received.
Let me see. I have extra copy.
से काउंटर लो. हेडमास्टर काउंटर सब सल्ला नहीं. अब ना किसी और. Give him a copy. I'll take it up tomorrow.
My lord.
Let a copy of the counter filed by opposite party number 5 be served upon learned counsel for the petitioner. List this matter tomorrow.
Item 22.
Just before vacation, we have received the counter. Lordship, I pray for 1 week time to file rejoinder.
I have objection, my lord. Since the selection of Anganwadi helpers of the year 2019, they got selected, the petitioner selected in irregular manner. Her selection has been quashed. My order has been issued to give appointment to me. My appointment has been waited since 5 years, my lord. And they received counter since long, more than 2-3 months. All last occasion also took time for filing rejoinders. And
Lordship, we have just received on before vacation.
Only thing is the question who got maximum votes in the Mahila Sabha is equal to be elected. Sub-collector categorically object.
There is an interim order against you.
Interim. Due to interim order, I am.
When did you receive the counter? Counter filed by?
Opposite part number 3 and 4, I have received on 8/5/24.
By the CDPO.
Achha. But on 10/11/2023, you had also sought for 2 weeks time to file rejoinder. Rejoinder to
my counter.
To your counter, yes. Again on December also the same.
Lordship, on state, I want to file counter.
That rejoinder has not been filed.
Lordship, only I pray for a short date.
After 3 occasions.
Any week next date, Lordship. Lordship, on that stay vacation of stay copy also not received.
Counter.
Vacation को final पे hearing कर दो. All right.
Short date.
As prayed for by learned counsel for opposite party number.
Read petitioners.
I
am sorry. I was filed the counsel for the petitioner. Release this matter next week.
Next week.
On 4th July. Rejoinder if any be filed in the meantime positively. No further time shall be granted for the purpose.
Interim
order to continue.
Item 23. Item 23, Your Lordship, the petitioner while working as Sikya Psych, he was terminated
Right order under annexure 6, Your Lordship. Challenging that, he approached this honorable court in 22-124 or 21. When in this honorable court directed to approach the OP number what for redressal of his grievance. First one to
approach the
OP number 1, Your Lordship. For redressal of his grievance, Your Lordship. Against the order of
disengagement.
Thereafter, his case has been rejected, Your Lordship. And Your Lordship, in the counter has been filed, I seek for further time to file the rejoinder, Your Lordship.
What rejoinder? Why is it necessary to file rejoinder?
Yes, my lord.
On what ground has it been rejected? I hold that the petitioner has violated the terms and conditions of the agreement. Why? What was the reason?
So, Your Lordship, may kindly see annexure 6, Your Lordship.
Annexure 6, yes.
Right, annexure 6. They have terminated.
Referring to clause 16 and 17.
Retrospectively, Your Lordship.
Maybe. Why? What is the reason? What prompted them to dismiss you?
Violation of clause 16 and 17.
Why? What is that?
Unauthorized absence, Your Lordship.
Yeah?
Unauthorized absence.
Unauthorized absence. All right.
So therefore, it is like a rejoinder.
What is the counter?
Counter, my lord. District Project Coordinator has filed the counter.
Unauthorized absence from 3/7/2013 to 2/3/2014.
2/3/2014.
Yes. What is your reply to that? You are unauthorizedly absent.
So cause was also issued.
So how does it? How will it help you?
He did supply so cause. That is the counter, paragraph 9.
Paragraph 9.
Lordship, if Your Lordship will see annexure 6, my service has been terminated with effect from 3/7/2013. Whereas in the impugn order, which has been annexed at annexure 8, relevant pages, page 41. Your Lordship may see in 2015, I was issued with the show cause, and they themselves admit that I was working and I was signing the attendance register, which was maintained with the village education committee, Your Lordship.
Where is it? Where is it? Where have they admitted?
Your Lordship may kindly see.
What fact do you want to bring in through rejoinder?
Lordship, regarding the leave application.
What
we
you
also further examine this matter for the society.
All right, let's this matter on 4 July as paid for. Rejoinder, if any, be filed in the meantime.
It's some more time, Your Lordship.
Really?
1 week.
10th July. 10 July.
Get from.
He had earlier approached twice also.
Now we'll see. Yes.
Item 24.
The wife has filed the present transfer.
Interim report as mediator.
Mediation report.
First July को
एक साथ the mediation specifically declared that the mediation is unsuccess because the wife.
एक साथ को रखी चिंता में ता पूर्व किंतु hold करिया.
Alright.
Mr. Procedural, let it come after yeah.
हाँ.
Fail कला हमें जो report असले fail कला आज ही fail कर जो बोले कहले कितना.
एक साथ पढ़ो के any date रखूं.
With your experience, you should try to have a successful mediation.
Because I tried. 2 options was there. Either you keep me. No. The father of the petitioner, the opposite party husband, and his mother, both 3 are present. They demand that I will never keep. All right, if you want to divorce according to your status and my so far my age is concerned, you pay some permanent alimony? No permanent alimony. In that regard, what I have to do.
See you negative settlement कौन थी 13B file करी जो application.
File कर देते ले इतना किसी permanent alimony दे दी थी ले तो sorry था से कुछ permanent alimony हम दबानी. अब भी रखी बनी ताल से जगह रे my lord what I have to do.
दबाव का बोला ये आगे
कम दो चांस अति बेसी दो कुछ.
नहीं कथा ना सी
The software engineer more than
the
one
truth has come out from Mr. Patnaik's mouth. मतलब कौन ही उचित क्या उठी के अच्छा the report of the mediator indicates that The next date of mediation is fixed to 1st of July. Let's this matter on. Eh? नहीं था पर 11 July.
Item 25.
25.
For the petitioner wife, my lord, last occasion, my lord, instruction was sought for whether the case may be transferred to another place, that is Keonjhar, my lord.
Lordship may peruse the last order, that is 15/5/2024.
Yes, sir.
Where my lord was pleased to take note of my submission.
And he wanted to take
time.
What is your?
As per instruction, it is not possible on the part of the petitioner to go as because the distance is near about more than 160 kilometers.
Where is he residing?
He is residing at Raulkela, my lord.
She's working as a
Clerk.
Clerk in a PNB, my lord, posted at Boingala. I am working as a junior engineer, Karanjia. From Google Map today morning, I find 89.3 kilometers. It will take 2 hours if she comes from Boningo to Keonjhar, straight national highway. If I go from Karanjia, it is 51.6 kilometers. It will take 1 or 50 minutes. There is no hurdle. Keonjhar is the best place I have suggested, and I also will lordship to that.
Where is the proceeding pending now?
Raidangpur.
Raidangpur.
No, proceeding court pending.
Court pending ଅଛି.
Raidangpur, my lord.
Raidangpur, no. Raidangpur ଅଛି.
Raidangpur is nearer to Boni.
Boni.
Raidangpur is sorry, I'm Raidangpur is nearer to Karanjia.
Karanjia. Because I am
ठाकुर मुंडा.
आया. किंतु बर्तमान जो मैप में देखिली पूरा स्ट्रेट है नेशनल हाईवे.
से स्ट्रेट जे स्टेटस जिन देखा जाଉଛି ସେମିତି ନୁହେଁ. ସେମିତି ଆପଣ ସେଥିରେ ଗଲେ ଅସୁବିଧାରେ ପଡ଼ିବେ ଆଜ୍ଞା. ସେଥିରେ ଗଲେ ଆପଣ ଯେ ବଣ ଜଙ୍ଗଲ କୋଉଠି ବାହାରିବେ ତାର କିଛି ଠିକ୍ ନାହିଁ.
ନେଶନାଲ ଏନଏଚ
କରଞ୍ଜିଆ ଦେନ୍ ଠାକୁର ମୁଣ୍ଡା ଦେନ୍ ରାଇରଙ୍ଗପୁର.
ନାଇଁ ମୁଁ ଆଜ୍ଞା
I don't know ସେ କଥା ମୁଁ କହୁନି. ବଣେଇ is on the different line altogether. କେଉଁଝର ଗୋଟେ ବି ହବ ବଣେଇ.
କେଉଁଝର ଗୋଟେ
ପାଲଗଡ଼ା ଦେଇକି.
ଆଜ୍ଞା ଇଜିଅର ଏକଦମ.
ପାଲଗଡ଼ା ଦେଇକି ବାରକୋଟ ରୁ ବଣେଇ. ମୁଁ different route altogether.
ପୁରା ମ୍ୟାପ୍ ଟା ବାହାର କରିଛି.
No.
ସେଥିପାଇଁ ଆପଣ କହିଥିଲେ ଯେ କେଉଁଝରଟା ବି ମିଡିଲ ପ୍ଲେସ୍ ସମସ୍ତ ପାଇଁ ସୁବିଧା.
I just suggested if both of you agree, we can bring it to, but Raidangpur may be difficult.
ନାଇଁ ରାଇରଙ୍ଗପୁର ମୁଁ ବି କହୁଛି. କେଉଁଝରକୁ ହଉ ଯଦି ଆପଣ
what do you say?
Case may be transferred to Raulkela, my lord.
Why not Koraput? Why not Koraput then?
Then the wife is residing at Raulkela, my lord.
ବଣିଗଡ଼ ନା ଚାକିରି କରୁଛି.
ବଣେଇ Raulkela.
ସେଟା ଆଜ୍ଞା ବିଜି ରୋଡ ଟା ଟ୍ରକ୍ ଫକ୍ ଯାଉଛି ସବୁ ଆଇରନ୍ ଓର.
So you take further instruction from your client. Keonjhar could be a better place. Keonjhar could be a better place. Then there is nothing to force. Then I will consider the case on merit upon. See, you are Mr. B. Dalai.
M.R. Das.
M.R.
Das.
Sri M.R. Das, the counsel appearing for the petitioner, wants to take further instructions from his client as to if she would be agreeable to the case being conducted at Keonjhar. Is this matter? Next week. Next week.
Interim order.
Interim order to continue.
Adjournment था तो petition देगा.
सही यहाँ interim order से adjournment है.
Item 26.
Wife's application for transfer of civil proceeding from Jagatsinghpur to Bhubaneswar.
Notice was issued.
Notice was issued. It was solved, but they are not appearing through any lawyer. And
Oh, that is why one more opportunity was granted.
yes, sir.
Nobody is appearing, we allow it.
Nobody has appeared.
All right. We grant granting him liberty to appear through virtual mode. Allow it. I'll allow it. You are residing at? Where are you residing?
I am residing at Bhubaneswar.
You want it to be transferred to Bhubaneswar?
Bhubaneswar. Because she is a lady having a kid of 1 year, and she is also working at Jajpur Boni or something, Sukinda Jajpur. So she leaving the baby at home. She is going all through from Bhubaneswar to Sukinda every day. And on the other hand, the husband is staying at Puri. She is prosecuting his study there on some diploma course. He is a doctor.
Yes.
He is doing his
diploma in obstetrics and gynecology. So he is very much staying at Puri. So it is there will be no inconvenience on his part to come from Puri to Bhubaneswar to appear in the case.
All right.
On the other hand, I shall have to go to Jagatsinghpur with
Petitioner, who is the wife of opposite party, seeks transfer of civil proceeding number 1 of 2024, pending before the learned judge, Family Court, Jagatsinghpur, to the Court of Learned Judge, Family Court, Bhubaneswar. Therefore, transfer has been made on the ground that the petitioner is residing at Bhubaneswar with a small child. Stop. Moreover, it would be, moreover, she is working as a dental surgeon at CHC Sukinda. Stop. As such, in order to attend to her duties, she has to leave her child in the custody of her parents at Bhubaneswar. Under such circumstances, it would be inconvenient for her to travel to Jagatsinghpur to attend the court on the dates fixed. Stop. It is further submitted. It is submitted by the Mishra Learned Counsel for the petitioner that her husband, the petitioner's husband, is working as a doctor at Puri. It would therefore be more convenient. It would therefore be also convenient for him if the case is transferred to Bhubaneswar. Stop. Having regard to the above facts and the submissions made, I am inclined to allow the therefore transfer. Stop. It is directed that the proceeding in such and such be transferred to such and such court. The transferee court is directed to issue notice of appearance to the parties upon receipt of records. So it shall be open to the opposite party to seek permission of the court to appear through virtual mode if he so desires.
Item 27.
Yes.
They have already filed the affidavit, your lordship. Now, since the district judge's father was described.
Yes.
The file that it can be transferred to Cuttack.
Today I am filing affidavit on the basis of instruction, it can be transferred to Cuttack. Paragraph 4. I have stated that
this is an application for transfer of arbitration appeal number 13 of 2023, presently pending before the district judge, Khordha at Bhubaneswar, to the to Cuttack. So it is the prayer for transfer has been made on the ground that the incumbent district judge of Khordha has recused from hearing the matter as the arbitration award impugned before him was passed by his father, a retired judicial officer. So, Learned Senior Counsel, Learned Sri D.P. Nanda, Learned Senior Counsel, submits that the incumbent district judge cannot obviously hear the matter as he would be concerned. Stop. Sri D.R. Bhokta, Learned Counsel appearing for the railways will for the railways files counter affidavit wherein the
we have agreed to transfer them.
Wherein the proposal wherein the prayer for transfer has been accepted. Sri Bhokta further submits that considering the grounds cited for transfer, the railways I have no objection. Stop, para. Considering the submissions and the grounds on which the application for transfer has been filed, this court is willing to allow the same. Stop. It is directed that the proceeding in arbitration appeal number 13 of 2023, pending before Learned District Judge Khorda at Bhubaneswar, be transferred to the Court of Learned District Judge Cuttack. He is hearing the arbitration appeals.
Yes.
The parties are directed to act upon receipt of notice of appearance to be issued by the transferee court upon receipt of records. Yes.
Hon'Ble.
Item 28.
Lordship. So this is a case of Procedural 2, law, and here the accused in constitution to 18/2021. And
Lordship call for that deposition copies and
already Lordship record have come. Lordship the last time Lordship seen that records. Lordship's direction record must have come.
Scanned copies of depositions of all the witnesses.
Last time also seen that.
This is a case of murder.
Yes, murder.
Yes. What happened?
I'll call for the records and Lordship the record is there also.
Who was killed?
But the allegations are the father and the present petitioner, son and sister. In the minute, sister has already been released on bail and father is in custody, son is in custody.
One Ratha Naik, his son Badal Naik, another family quarreled with her husband due to Gharabadi boundary.
But two witnesses are there very important.
Just. Sikkim Ratha Naik, Badal Naik and his family members carrying lathi, stick and farsa suddenly attacked her husband, for which her husband fell down on the ground.
Yes.
Rathia Naik assaulted on her head.
Yes.
By means of a lathi.
Yes.
So the allegation is against Rathia Naik.
no matter Rakesh alleged Badal is the present petition is Rakesh alleged Badal is
so who are the principal witnesses?
PW1 who is the informant
and the husband
PW3 also mattered.
PW5 and 1. Those are important witnesses.
Accused Rathia assaulted to the head of my husband twice with a lathi and accused Badal assaulted to the head of my husband by a farsa.
Yes.
And accused Alina assaulted him to which Alina has been granted bail.
Yes.
Yes. But it was actually directly upon marriage.
Also seized from the presentation.
May submit, the last time Lordship had this matter. Peter Lordship, the witness of PW1. That is the cross-examination, the name of the accused has not been mentioned there.
Can they can?
Lordship, the PW1. But para 4 married, para 4 minutes.
Yes.
It is a fact that the occurrence took place due to land dispute. The occurrence took place just in front of my house. The house of the accused person is adjacent to our house. No outsiders were present at the time of occurrence. That took place at 5 p.m. My ja Basant Naik was present at that time. It is a fact that there was a quarrel between my husband and the accused persons prior to the assault of my husband. There was no dispute between my husband and the accused persons prior to the day of occurrence. It is not a fact that I have not stated before the police that accused Rathia gave 2 blows to the head of my husband, father, with a lathi, and that Basanta and Barsha assaulted him by kicks, and that my Dadeshwara and father-in-law, being informed, came and shifted my husband.
You are not disputing that Badal
Kotha. They are not disputing. I am not disputing. I am for the son now.
Sir, see Badal Kotha, Badal Kotha.
No, Rathia.
You are Rathia?
Yes.
No. It's Rakesh alleged.
Rakesh Badal. I put Badal. But they कहते हैं तब बापा.
Rathia. जो cross examination पार्ट पढ़ लिया 5 पे कौन करे? It is not a fact that I have not stated before police that accused Rathia gave 2 blows to the same part of dispute करते हैं.
हाँ सिर्फ.
और बादल भी मारेगा के साथ अपन dispute करना था. अपन you have not given a suggestion that it is a false statement.
Is that there some non trial court ऐसे question जो trial.
अच्छा ये बता wrong मैंने trial court wrong पर चिंती.
सर नहीं ले जैसे सिर्फ cross कर ले तो question Okay, I will ठीक है
Understand, sir? Mr. Patnaik ko apna are you a newcomer or what?
नहीं sir
This is a cross examination. You are referring to that cross examination. That suggestion has not been given to the witness.
Yes, that's true. That I am admitting.
So because it is not a fact that I had not stated about this battle striking the head of my father by means of a farsa. Se bata kaun specifically anitande.
नहीं से हाँ
admission नहीं.
I asked that to college corner
admission तो
exactly that also that wrong they have done. That's so much that घटन को sir sir incident है ना 7 PM सकाळ the next day समला 7 रे this and the medical report I'll show that the external medical reports कहउसंगी second harassment किसी दे and pedal fight the first time use is नहीं accused को हिसाब रे के information अछि नि के कोन हेछि त pedal fight pedal
support आपन against
yes sir
thereafter his son Badal Naik assaulted my younger brother with a farsa and my brother fell down on the ground
says report किस तरह नहीं sir injury report sir तो किस नहीं sir
कौन injury report where is that injury report let us see that postmortem report अछि
yes ma'am
let us see
postmortem I also got that postmortem
যদি কিছু আছে আইতো তো ভালো টাইম এই সময় নষ্ট করে
স্যার তার পিরিয়ড 5 টা পড়ি স্যার
তো পড়ি চালি
পিরিয়ড 5
মো পড়ি করে আপনকো
নাই পিরিয়ড 5 টা স্যার
পিরিয়ড 5 पर পড়ুছি
নাই
বড় নায়ক
हां यस से तार से क्रॉस से देखुन सर ई जे निजे डिसीज ता से स्कूटर बसी गला हॉस्पिटल माने से दिन से कहले हार्ट प्रेशर से मर गया हां दैट इज नॉट टेस्ट लोग सब प्रेशर पड़ जी किछ नहीं पड़ी देखो सर कॉलेज गाइज तो पारक पोट सर को सर तार इंटेंशन कोन ना सीआसी ता माने डिसीज आज
ओडिसा बाबू कोन इंटेंशन नहीं पारे जने लोक जदी ଗୋଟେ फारसारे आ जने लोक को मुंडी मारे कोन इंटेंशन नहीं करे
जस्ट ठीक रे मुंडा वाडे सर ठीक सर हमको बीटा सर पढु सर
फॉरन प्लीज
सर इट इज अ फैक्ट दैट आई कैन नॉट से the contents of exhibit P2 P1 wife information of the occurrence over phone. The distance between our village and Denkanal is about 12 kilometers. I received the phone call from my wife at about 6:30 PM on the day of occurrence. I reached home with 7 PM that day. I brought the injured to Denkanal hospital in my scooty. The injured sat on my scooty holding me. Don't you see that? The situation sir देखो सर तो बड़ा लोग फास्ट से हानुची बट सर ता स्कूटर बस के जाउची ता सो ता नेक्स्ट डे होची ड्यू टू प्रॉपर ट्रीटमेंट ता से करना ता दिस एक्सीडेंट दैट इज दिस तो इंटेंस सर डेथ है आई डोंट डिस्प्यूट दैट डिस्प्यूट डेथ है देयर इज अ क्वारल the intention of this present petitioner प्रश्न दैट ता फास्टर मारुची स्कूटर निजे डीसी ता से स्कूटर में नेक्स्ट से मारुची so the intensive party I'm saying
that is due to craniocerebral
injury
and inquest report also I have
so that is the intention already present consideration proceed
क्या होने
sir the other question nobody so nobody there in now is so that this is a lesson said that the disease scooter बस जाऊ सर मेडिकल को हां से तार नेक्स्ट से चली जाऊ छी तब देखो सर ए फास्ट यूज कर लोगो फास्ट यूज कर बापा पुओ और भौनी
the petitioner is in custody in connection with such and such case
सर नो के दिन था डिसमिस कर के दिन था सर
ना
सर दैट इज ऑल्सो के
मन बोल तो नहीं बोल
सर के अपन सर रखी दी छुट्टी पर के बड़े इतने सर सुनले पर था सर लोग दे दे 21 सर रहिलन आगे दिन सर सर डिसमिस करन आगे नो सर लेट अस सर कौन करे सर परिवर्तन दिस इज द रीजन सर नीचे सर दिस इज
matter when moved
right
item 29 Osif has granted interim bail for 3 months, my lord. This is the first extension application. Local person.
considering the submission the interim bail granted by order dated so and so is extended by for the period of 1 month
Item 30, 1 month, my lord. 2 months. Local person.
6 weeks
My lord.
Lordship granted pass the order 12 to 23.
12/12/2023
So for the reasons I have stated in paragraph 2.
to move forward so they should be released on bail तो इतना
कहतला जे surrender करि पर ना
extension पे दोना थी extension कर दो
my lord petition has given was given
please ये पे आपण आसबी What, Mr. Mahathir, I thought a very serious matter is there. I was getting ready mentally.
Gap नहीं जाए तो सेट पे
You ask the junior Mr. Mahathir to have.
he is doing it.
So why when the senior counsel like you come, I was mortally afraid that some serious matter is there. I was mentally preparing to face you. कौन इतना अच्छे अपन आसवे ये? कितने दिन के इतना बार-बार?
बार-बार 23
बार-बार दिए 23? नमो?
हाँ बार-बार 23
for 2 weeks.
अच्छा, Sri P.K. Mahathir, learned counsel appearing for the learned senior counsel submits that because of certain unavoidable circumstances and the unavoidable circumstances followed by the general elections, the petitioner could not appear before the court below within the stipulated period. Considering the submissions, 2 weeks further time is allowed to the petitioner to surrender. Stop. It is made clear that no further time shall be.
Yes.
So that he will surrender.
Yes.
Item 31.
Item 31.
Milo.
Sorry. Yes.
Milo. I appear you 1/11/23, but due to after hearing sometimes due to disconnect the connection, due to disconnect the connection, again repeated listed again the 2/11/23 again listed. That is the some inevitable circumstance. I unable to reach the information to listed the 2/11/23. I never imagined that because 1/11/23 I already appear and submission some points and disconnect the line, disconnect the connection. Then
It was dismissed. He has filed a restoration application.
No, he is appearing in person. Are you a lawyer, sir?
Yes, sir.
All right. What was dismissed? कौन matter था? CRLMC.
Non-appearance, sir.
All right. Restored.
Already I appeared.
Restored. Yes.
32.
My lord, the petitioner ଆସିଛି file. Yes.
dispose of ହେଇଯାଇଛି ସେ ଆଗଟା
ଆରଟା
ଆଜ୍ଞା
ଫାଇଲଟା ଆସିଛି କଣ ଓ ଯୋଉ କାଲି ଦେଖୁଥିଲେ
ଆଜ୍ଞା
ଦେଖେ
2021 ରେ ଯୋଉ
ସେ ସାଙ୍ଗରେ ଅଛି
ନାଇଁ 21 ଏଟା ଅଛି 17/5/22 ରେ ଡିସ୍ପୋଜ ଅଫ ହେଇଛି
ନାଇଁ 21
ସେଟା ଦେଖଉନି ଏଥିରେ 17/5 deceased wanted to marry the petitioner being attracted to the brother. However, when he refused to marry, she committed suicide. Out from the dying declaration, the victim pouring spirit on her and setting her on fire. Spirit directly on the using the
my lord खाली स्टेटमेंट देखो मो स्टेटमेंट सब सर्टिफिकेट को भी दे देछि
आउ कोन स्टेटमेंट
नहीं मोटे हेई नहीं मोटे तंगर जो डाइंग डिक्लेरेशन आदो हेई नहीं समस्त साखी भी कोई
yeah injury is called as superficial epidermal burn wounds amounting to 95% to 97% of the total body surface
आज्ञा ठीक बर्न इंजुरी किंतु सेल्फ इमोलेशन ने भी हेई परिबो डॉक्टर भी कहि
हबो
हां किंतु केही आई विटनेस
सेल्फ इमोलेशन अब आपन मन से मन काई कहि जाय
नहीं केही कोई नांती साखी देखनाती मु दे दी सब सर्टिफिकेट को
No, can we say PW6 madam who is the doctor
yes
nobody has said anything against him
no
madam PW6 madam
no
some of the witnesses turn
one victim namely Sashikanta Mishra of the body of the victim you are wife
no yes doctor
पिला से मैरिज करियो प्रस्ताव पिला देइथिले ता बापा राजी हेले नै ताक भाई भी स्टेटमेंट रो कहछन जे
the victim remained in our hospital for 5 minutes for treatment after providing primary first aid I referred her to MKCG. Victim was crying and shouting at that time, though the victim was able to speak, but her voice was not clear. But it is under the victim also sustained burn injuries on her face, including ear, mouth.
विक्टिम रे निज भाई भी कहछन्ती जे हम सान भणी मैरिज कला पर से टिक मेंटली डिस्टर्ब थिले
आउ की कहना थी अने सखी
न कोन सखी कहना थी
सिक्सटा पढली पर
हां से तार ना कहछ the victim stated that one Krishna Chandra Sahu
kai se kata nai PWC score कहली
only the
PW6 तो कोटी कॉल
डॉक्टर बी अस्मिता पात्र
हाँ
ସେଇଥିରେ ଫାଷ୍ଟ ପାରାର ମାଇଲର ଦो ବହୁତ
victim stated that one question this will be hearsay strictly speaking this will be hearsay
and then my lord another doctor who was magistrate who has recorded the dying declaration
ସେଇଟା ଦେଖିଏ
PW17 my
PW17
my lord
कौन dying declaration record ହେଇଛି
dying declaration was recorded it was also exhibited
ସେ ସେଥିରେ କହିଛନ୍ତି ଯେ ମୁଁ ଆସିଲା ବେଳକୁ ପୋଲିସ ଟାଇପ କରି ରଖିଥିଲେ ଡାକ୍ତର ବି କହିଛନ୍ତି ମୁଁ ସାଇନ କରିନାହିଁ ନା ଅନ୍ୟ ଯୋଉ ଦି ଜଣ ଥିଲେ ସେ କହୁଛନ୍ତି ଆମେ ପଢିନୁ କଣ ହେଇଛି
thereafter I recorded the statement of the injured in question answer form when the injured expressed her inability to give further statement I stopped the recording of the statement of the injured I read over and explained to her after recording the statement I
ମାତ୍ର 5-6 ମିନିଟ ସେଠି ରହି
heinous crime
ନାଇଁ ନାଇଁ 5-6 ମିନିଟ ରହିଛନ୍ତି ମାତ୍ର
ଜଘନ୍ୟ ହତ୍ୟାକାଣ୍ଡ
ନାଇଁ ନୁହେଁ ହତ୍ୟାକାଣ୍ଡ ଆପଣ ଦେଖୁନାହାନ୍ତି ଷ୍ଟେଟମେଣ୍ଟ ଗୁଡା ଦେଖୁନାହାନ୍ତି
ହବନି ମିଷ୍ଟର ରାଉତ
ଦେଖନ୍ତୁ ତାପରେ ଆପଣ ନ
ଦେଖିସାରିଲେଣି ଯାହା ଦେଖିବା କଥା ଦେଖିସାରିଲେଣି
ନାଇଁ ପୋଲିସ ଆଗରୁ ଲେଖିକି ରଖିଥିଲେ ସେ ସାଇନ କରୁଛନ୍ତି ସମସ୍ତେ
ସେଗୁଡା ଆପଣ ଟ୍ରାଏଲ ଆପଣ
19 ଜଣ ଏକ୍ସାମିନ ହେଇସାରିଲେଣି ମ୍ୟାଟେରିଆଲ ୱିଟନେସ୍ ଯିଏ ପ୍ରେଜେଣ୍ଟ ଥିଲେ ସେ କହିଛନ୍ତି ଆମେ ପଢିନୁ କଣ ସାଇନ ହେଇଛି ତାପରେ ସେ କହିଛନ୍ତି ଆମେ ପଚାରିଲା ବେଳେ ବି ଆମେ ନଥିଲୁ ଇଏ କହିଛନ୍ତି ଯେଉଁମାନେ ଥିଲେ ସେ କହୁଛନ୍ତି ଆମେ ନଥିଲୁ ଆମେ ଶୁଣିନୁ କିଛି
there is something called judicial conscience and unless that is satisfied
ପୁଣି ଜଣେ ଯଦି ଯଦି ପନିଶମେଣ୍ଟ ପାଇବ ଯଦି କନଭିକ୍ଟେଡ ହବ ପାଇବ ତାହେଲେ ଯଦି ନଥିବ ସେ ଆକ୍ଚୁଆଲି ନଥିଲା ବି ଇନଫ୍ୟାକ୍ଟ କେହି ବି ତା ଯେ ପ୍ରେଜେଣ୍ଟ
ନା କହିବ
ନାଇଁ କେହି କହିନାହାନ୍ତି ପରା ନା କେହି
ସେଇ victim ଯୋଉ
କହିବା ଅବସ୍ଥାରେ ନଥିଲେ
ମାନେ କାହିଁ ତାକୁ falsely implicate କରିବେ
ଇଏ ତାଙ୍କ ଦେଖୁନାହାନ୍ତି ଇଏଟା ସେଇ 6 ଯୋଉ ଇଏଟା ଦେଖିଲେ PW6 ପରେ କଣ କହିଛନ୍ତି ଦେଖନ୍ତୁ
this is the dying declaration it was exhibited
ନାଇଁ ଡାଇଂ ଡିକ୍ଲାରେସନ ଲେଖା ହେଇଛି କିନ୍ତୁ ଆକ୍ଚୁଆଲି ସେ ଡାଇଂ ଡିକ୍ଲାରେସନ ହେଇନି ମୋଟେ ପାରାଗ୍ରାଫ 3 ଟା ମୁଁ ଟିକେ ପଢୁଛି ୟାଙ୍କର ସେ କ୍ରସ୍ ଏକ୍ସାମିନେସନ କହିଛନ୍ତି ଡକ୍ଟର ମୁଁ ଟିକେ ପଢି ଦଉଛି ଖାଲି 2ଟା ପାରାଗ୍ରାଫ ତାପରେ The victim remained in our hospital for 5 minutes for treatment. After providing primary first treatment, I referred to MKCG hospital. At that time, victim was crying and shouting. Though the victim was able to speak, but her voice was not clear. But it is understood. The victim also sustained burn injury on her face, including ear, mouth, nose.
ଜଣେ ଆଜ୍ଞା executive magistrate ତହସିଲଦାର କମ executive magistrate OS officer why will he make a false endorsement
ନାଇଁ ସେ ପୋଲିସ କରିଛି ସେ କିଛି କହିଲା
ନା ନା ସେ ସାଇନ କରିଛନ୍ତି
ହଁ ସାଇନ କରିଛନ୍ତି
ଗଲା ହଁ in my opinion this was enough as a declaration bracket as she was constantly asking for water and trying to save her life is more important at this juncture
ଆଜ୍ଞା ଆଉ ମୁଁ ଷ୍ଟେଟମେଣ୍ଟଟା ଖାଲି ପଢୁଛି ଡକ୍ଟରଙ୍କର ସେ କହିଛନ୍ତି ସାର୍ଟିଫିକେଟ ଗିଭେନ୍ ବାଇ ମି ୱାଜ ଟାଇପ୍ଡ ବାଇ ପୋଲିସ ସେ ତା ମେଣ୍ଟାଲ
ଟାଇପିଂ ନାହିଁ there is nothing type ଏଟା ହାତରେ ଲେଖା ହେଇଛି ଦେଖୁନାହାନ୍ତି ଆଜ୍ଞା
ନାଇଁ ଇଏ ଯୋଉ ଦେଲେ ଯେ ସେ କହିବା ଅବସ୍ଥାରେ ଅଛନ୍ତି କି ନାହିଁ ସେ କହୁଛନ୍ତି ସେଟା ପୋଲିସ କିନ୍ତୁ 5 ମିନିଟ ଭିତରେ ରେକର୍ଡ କରିଦେଲେ ମାତ୍ର 5 ମିନିଟ ରହିଛନ୍ତି
କାହିଁ ହବନି
ଆଉ ଜଣେ ହେଲେ ସେ କହିଲେ ଆମେ ଶୁଣିନୁ ଡାଇଂ ଡିକ୍ଲାରେସନ
ହବନି
ସମସ୍ତେ ମନା କରିଛନ୍ତି ଆମେ ଶୁଣିନୁ 5 ମିନିଟ ଭିତରେ ଡାଇଂ ଡିକ୍ଲାରେସନ ହେଲା ଏଟା
you have made a gallant attempt
ଏଟା impossible ପୁରା
you have made a very good and gallant attempt but unsuccessful hobani the petitioner is in custody in connection with such and such case
interim କିଛି ଦିନ ପାଇଁ
କିଛି
ଆଇର ବାହାଘର ଅଛି
Mr. Das or Aniruddha Das is sitting here yesterday he was also making a similar prayer in a similar case and acid attack
2-3 ମାସ
କିଛି ହବ कुछ नहीं होगा
ଯାଉଛି କନଭିକ୍ସନ ହବ ତ ରହିବ
ଏଥିରେ ହବନି ଇଣ୍ଟରିମ୍ ବେଲ୍ ହବନି ଇଣ୍ଟରିମ୍ ବେଲ୍ ଏଟା ବନ୍ଦ କରୁ କେତେଗୁଡେ ପିଟିସନର and the victim were in love with each other when the victim proposed for marriage the petitioner turned down her request repeatedly
ନା petition turned down ବାପା
petitioner's father
victim's father
victims the victim and the petitioner wanted to marry but the proposal was objected to by the victim's father It is further alleged that the petitioner poured kerosene on the body of the victim and set her on fire, causing serious burn injury. She ultimately succumbed to such injuries. So, the kicker out, learned counsel for the petitioner, has drawn attention of the court to the depositions of several witnesses already examined during trial to submit that none of the witnesses has whispered anything against the petitioner so as to show his complicity. He further submits that the so-called dying declaration recorded by the executive magistrate is not worthy of acceptance because of the manner in which because of the role played by police in at that time. Then State Counsel opposes the prayer for bail by submitting that the postmortem report clearly reveals that the petitioner sustained burn injuries to the extent of 95-97%. He further submits that there is no reason to disbelieve the dying declaration, wherein the dying declaration, as it has been recorded by the responsible government officer. I have considered the rival submissions and have also gone through the case record, including the postmortem report and the dying declaration. So, it appears that the victim, it is seen that the victim has vividly, has clearly described the occurrence and has specifically named the petitioner of having poured kerosene and of setting her on fire. The grounds raised by the contentions advanced by Sri Raut can be considered only during trial. This court finds a strong prima facie case against the petitioner at this stage. Under such circumstances, I am not inclined to allow the prayer for bail, which is therefore rejected. Yes.
Let's say kerosene জায়গায় spirit হবে
spirit করে দেবো, kerosene করে দিচ্ছি। 32 ठीक है सर। Have you served a copy on? Have you taken instructions on this?
No, my lord.
We'll take it up next week. You take instructions.
My lord, but the ganja was seized from the vehicle, from the petitioner vehicle that belongs to UP registration. In the affidavit, he has stated that he is staying on a rented basis in CORAM. So I would take, and another ground is that is the health, regarding its health condition, you wanted interim bail. That I would take instruction from the jail authority whether actually.
No, these are all jail documents. You may take. These are all jail documents.
You can take instruction.
No, he has to
And
take.
the document is December 2023.
That was filed called for by the non trial court while considering.
Learned counsel for the petitioner has filed affidavit of the son of the petitioner, stating therein that his father, being engaged in very business in Koraput, is residing at Gaurapadar, PO Jaipur, District Koraput since 2019. A rent agreement has also been enclosed to the affidavit. Let a copy of the affidavit be served upon London State Council, who shall take instructions in this regard, and also instructions relating to, the governance made in the interim application. Is this matter next week?
No, my lord, one week after. Dita Jaguran, jail authority.
10 July. 10 July. Yes.
I know 34.
May 20 BC of the NPS Act, 111 Pille, in custody for about 3 years. And my lord has kindly to grant me interim bail for a period of 3 months, with the observation that the trial has been delayed substantially. But still then, the trial is pending and my lord has called for a report.
Report
to my instruction out of 21.
Flag clear. Flag clear खाली चिट्ठा अच्छी report कहीं. I am to furnish here under the report on the status of. कौन? Report of the Arudegiri PS case number 8, which was disposed of in the court of additional sessions come special judge. कौन तार माने टा बुझियोनी? 3/2024 dispose of ही चीज़ लिखुन. As per लिखिली पर, I am to furnish here under the report on the status of Arudegiri PS case number 107 dated 27/2021.
107. This is 105, my lord.
107 ना?
107.
107 ना?
Sorry. I'm sorry, ma'am.
Which was disposed of in the court of learning additional session judge come special judge. Talakum 3/2024.
Madam, may take it day after tomorrow.
Business matter day after tomorrow. See, बोले खलासी जीते अपन contact करना.
Monday, my lord, Monday actually पूछ देंगे.
Or business matter on Monday.
Thank you.
I don't know 35.
Man double bail. खलासी ला पर भी bail थी. क्यों खलासी थी कि भीतर थी?
नहीं, वो सिर्फ all the otherwise था.
Yes, item 35.
My lordship, item 35, I mean, virtual mode, my lordship.
Yes. Yes.
My lordship, the deposition copy, the recent trial which has been undergone, yesterday I received, my lordship. So I am out of Cuttack, my lordship. Kindly tomorrow I will submit the deposition copy and kindly taken on Monday, my lordship.
But you have given the copies of depositions. It is already there.
My lordship, recent deposition copy undergone is yesterday I received, my lord.
When do you want? Tomorrow?
Tomorrow.
Eyewitness manakar achi or entire ko. All right, release this matter tomorrow. As paid for.
Item 36.
May I please, your lordship, I can see the deposition copy of PW1 only. Only the language has been used. I am escorting that vehicle. Neither I am in the vehicle where the contraband article has been seized.
NCB.
State party. And I am inside the custody since 25/12/2020. Your lordship, I can see the PW1 evidence. For a moment.
Yes.
Why is the
just put it. I granted you interim bail for 4 months.
But to myself.
Oh, yes. You are Ajay Singh though? 7938. BLAPL number 7938 by order dated 10/11/2024.
May target that is with me, my lord. 7938. Within 4 months, sorry. 3 months. Your lordship.
Trial has not concluded.
No.
ଛାଡ ମୋର ଅଛି ଏଥିରେ କଣ କହୁଥିଲେ ଦେଖିବା
PW1 ମତେ କହୁଛନ୍ତି ମୁଁ ଏସ୍କର୍ଟ କରୁଥିଲି ପିଲା that much allegation PW1 ରେ ଲେଖିଛନ୍ତି Park near the Sukra Dhaba situated so and so, a Scorpio vehicle bearing so and so will escort the truck from Sambalpur to further the culprit concealed the contraband article in the cabin of truck but I was not there in the truck. The culprits concealed the contraband so on Ete moved from Bhubaneswar at around Ete moving. I was a member of the after arrival at Sukra Dhaba requested 2 persons to be witnesses and that has been alleged that the present petitioner, paragraph 2 of middle part page 7. 2 persons sitting rear of the Scorpio.
Mr. Das,
my lord.
रिलीज कर दो रिलीज कर दो एक बेंच रो किसी असुविधा नहीं आई एम नॉट सेइंग एनीथिंग आउट ऑफ ये रिलीज कर दे अपन यू विल गेट द रिलीफ मत बोल यस
Item 37.
Can it be next week? Because you watch.
Next week. Yeah, will this matter before any other bench next week with kind permission of Honorable the Chief Justice. Yes.
Obligatory.
Item 37. Lordship has directed to obtain instruction regarding the health condition of the petitioner's wife.
Yes.
Yes. I've obtained.
The certificate produced is authentic and genuine. She was referred to AIMS Bhubaneswar for consulting.
After that, the last. She was referred to AIMS.
Chivalini.
Na. Asunanti dakle bhi asunanti.
बेल छाड़ी वाला कथा
4 years small child.
ने बेल छाड़ देले पुणे असुविधा से किन देता के ना दिसी कोड जीपे कोन कोड
4 years small kid is there.
you read this
Right?
you read this instruction
I have not
no
seen.
no देखो
But my instruction that 4 years small kid is there.
সেটা তো আছে লেখা আছে
ଅଛି ତ?
ନାଇଁ ନାଇଁ ହଁ ପୁଅ ଅଛି ସେଟା ଲେଖା ହେଇଛି ବଟ୍ disease or genuine or not that is एम्स वाला ଡାକୁଛନ୍ତି ସେ ତ ଯାଉନି
एम्स रो ଦେଇଛୁ ନା हॉस्पिटल एम्स
हाँ
एम्स से प्रेस्क्रिप्शन देई चाहे फाइल एम्स प्रेस्क्रिप्शन ऑफ द documents I have filed.
United State Council has obtained written instructions that the medical documents enclosed to the IA are genuine, but the patient has not turned up for investigation.
No angiogram for angiogram.
For investigation, the same thing, investigation and treatment. The BP Pradhan Lieutenant Counsel for the petitioner submits that as there is no other male person available in the family, the wife of the petitioner could not visit the hospital for treatment. Considering the submissions and the fact that the medical documents are genuine, have been found to be genuine, I am inclined to take a lenient view. The petitioner is directed to be released. Let the petitioner be
use quantity and several antecedents. And next matter also.
Oh, data case, data case.
I will grant him bail for only 4 weeks.
Local,
4 weeks.
Local, not
local.
4 weeks.
But
only for 4 weeks.
every alternate day he will appear.
Yes,
before
any
STF.
condition lots may impose.
Let the petitioner be released on interim bail for a period of 4 weeks. Condition current 1, he shall appear before the IAC of Kothana.
STF, my lord.
STF,
Bhubaneswar.
He will appear before the STF. So the STF will carry Kothana, STF police station Kothana.
STF police station.
STF police station Bhubaneswar. Where is he is a person from? Khorda.
Khorda. Jotni Khorda. Task Force Crime Branch Bhubaneswar.
Twice a week. And such facts shall be certified by the IAC to the concerned court once in a week. He shall not concern. Yes.
Next matter.
Same.
Fix a date. Fix a date, my lord.
Yes.
Fix a date.
Place this matter on
31st July.
31st July. 4 weeks 31st July. ठीक है. item 39 next point data same setri bi ia pakaishanti seta thau simply adjourn 38 same petitioner
Okay.
seta thau
Same order. खाली police station टा change हो गलो.
सेम ऑर्डर काहे हबो तो गोटे केस रे गला सेम अब तो जिबे कोन तो रिलीज
जीव केंदी.
हां कहि की
Okay.
interim being granted in one case will not the other case will not be a bar. How can it be a bar?
से केस तो interim bail है ना.
No, no. ये case interim bail है. ये specific direction है interim bail to be released. So will be released.
Okay.
आरा केस रे भी कर दीथन. There may be technical difficulty. दीथन केस रे कर दो. दीथन केस रे कर दो. There may be some technical difficulty. Yes. Item 39. से police station टा कौन? सेटा सेम सेटा भुवनेश्वर STF केस नंबर टा
Case number.
PS case number 5 of 22 yes 39 item 39
Ballot under section 341, 323, 324, 326.
Ranjit Rai
On last occasion, there are 3 injury reports.
she wanted to know that 3 injury reports how it case of 307 326 in two of the injury reports there was a reference to road traffic accident but he was gone to the hospital in a unconscious stage, my lord, where doctor said that road accident was there. Thereafter, he narrated the. So he wrongly said that. Yes, since he was unconscious, he said that it may be. Yes, that's why. Yes.
All injury are simple in nature, my lord.
Now, in one of that, he has undergone 3 operations. That is the instruction. He has undergone 3 operations. Operation. Previous be achieved. Page 40.
Road accident. RTA in column 1. HO RTA road traffic accident.
Yes, a road traffic accident has been explained now. Yes.
One grievous injury.
Then another there is a plastic surgeon to opine about severity of wound. Then left leg grievous injury. You can show you machine na ko? Yes.
Wind over left arm.
Say injured examined ho. Injured examined ho tapar likhe.
A palm injury. हाथ palm range.
Multiple injuries all over the body. Yes. So that reveals the intention. That reveals the intention. Baji aji to हाथ रे. Multiple laceration, lacerated wounds, lacerated knee, lacerated abrasion. बहुत injury है.
Later on 15th of October 2023, on last occasion, page number 38.
No, Mr. Panda.
All injuries are simple.
No, Mr. Panda. I'm not inclined. I'm not inclined. 1000. How many? It clearly shows the intention to kill.
After 5 days of occurrence, the informant lodged affair. And kindly seen the affair. Affair actually is other statement, one others Dubey, which co-accused in this case, attacked on the injured Abhishek Pandey, the injured person, and he got caught injury in hand. And one Kanha Porida, who also attacked for that multiple injury on backside. But there is nothing against the present petitioner to commit the alleged crime, my lord.
There is specific allegation against others and Kanha.
Yes,
and the present petitioner Ranjit Rai of habitual. What is the motorcycle and all of a sudden Mr. Mishra, find out the 161 of the injured. You have the 161? Yes. Read it. Let's go. इंजोर्ड वाला से कौन राहुल पांडे ना राहुल पांडे अभिषेक पांडे ठीक है अरे सीधा बंद ही कि एसी तो ठीक है गरम होचे कि संपाई जाऊ बंद करते अभिषेक पांडे स्टेटमेंट इज नॉट दोन वाला नहीं Do you have the statement of 161 of the Abhishek Punda, the injured?
Not here.
Abhishek Pandey nahi hai. That's right. After hearing the counsel for the parties, this court would like to produce the statement of the injured, Abhishek Pandey. The state council shall produce the same. Let this matter next week.
Item 40. And in this case, 39, it was earlier rejected by your lordship.
Yes, yes. Have rejected. I know.
Anticipatory bail.
I know. This is also anticipatory.
That was rejected.
Why is the police not arresting him? There is no bar to arrest. There is no course of action order. Achi.
12444 of 23.
Acha, how? Till such time, there is no course of action. Interim order to continue. Yes.
May I please, Your Lordship? Yesterday, Your Lordship had called for the record, ABL appeal 129 of 2024. That is the bail application before.
That has been filed by Amita Mahanti.
My lord. Amita Mahanti and Narayan Mahanti. In between, Narayan Mahanti arrested and he released on bail, my lord.
Amita Mahanti and Narayan Mahanti.
My lord.
A petition ki file question.
At the present case is Amita Mahanti.
That is pending. What happened to that? That is pending. Amita Mahanti is pending.
My lord.
129.
Amita Mahanti pending. Like, କାଲି ମତେ ପଚାରିଥିଲେ ଯେ ଯୋଉ ବେଲ୍ ଆପ୍ଲିକେସନ ଟା ବିଫୋର ରେଜିଷ୍ଟ୍ରେସନ ଅଫ ଏଫଆଇଆର ହେଇଥିଲା ନା ନାଇଁ ସେଟା ପାଇଁ ରେକର୍ଡ ଟା ମଗେଇଥିଲି
ସେଥିରେ ଅର୍ଡର କଣ ହେଇଥିଲା
ସେଇଟାରେ ଅର୍ଡର
ଲେଖିଛନ୍ତି after perusing the FIR my lordship see
ସେଇଟା
the petitions have not been named in the FIR
actually ସେତେବେଳେ ଏଫଆଇଆର ଲodge ହେଇ ନଥିଲା ଏଫଆଇଆର ଲodge ହେଲା ଅନଡେଟେଡ FIR lodge ହେଲା 15th March 2023 ଆଉ order pass ହେଇଥିଲା ସେତେବେଳେ January month
all right
my lord
so this is basically a civil dispute
my lord
isn't it the petitioner is apprehending arrest in connection with such and such case it is alleged that the ତାଙ୍କ ନାଁ ତ ନାହିଁ
ମାନେ forwarding report age because the account
what it seems my lord that Amita Mahanti account has been used that Amita Mahanti's husband has some the informant that is the husband of the been deposited in her account so the husband of the petitioner namely Narayan Mahanti along with his associate Shankar Sahu took 50 lakhs or 50,000?
50 lakhs, ma'am.
50 lakhs from the informant on the pretext of selling him a truck after auction by the financer. However, they did not provide him with the truck nor returned the amount except rupees 40,50,000. It is alleged that insofar as the petitioner is concerned, it is alleged that her bank account has been utilized in the transaction. There is no other allegation against the petitioner. It is further submitted that the co-accused Narayan Mahanti has in the meantime been arrested and released on bail by the court below. That's all.
My lord.
Under such circumstances, surrender, release on bail.
Item
41.
The co-accused has been released on bail. That matter, auto matter.
Again?
302 and 307. And
co-accused, Hazari Behara.
Yes.
Yes. Similar order, my lord, that injured who has stated the name of Niranjan, Papu and Swadhin during TI parade. Similar order.
Similar order, কিন্তু এখানে যে paragraph 7 টা কাটতে দেব also for the informant nobody is appearing Mr. Mahanti for the informant
no
তো সেই পার্টটা কাটতে দেব ହେଲା same order
গতকাল এই যে অর্ডার রে কন্ডিশন নে
Sunday କରିଦେଇଥିଲେ modify କରିଦେଇଥିଲେ ସେଇଟା alternate day ଆସିଯାଉଛି
Every Sunday ବୋଲି କରିଦେବ।
every Sunday 10 AM
42. May I please, madam?
Offense under section 120B, 120B, 37 and 411, 34 IPC matters. Illegal transporting of coal matter, you also allow two number of coagus, you also be
Owner of the vehicle.
oh no. Two number of by the ABL bill of 5583 dated of 2024 dated March of 2026, another ABL bill 5586 of 2024 Punachandra Das, two number of coagus dated March of 2026, you also. Vacation code ଦି ଜଣ ହେଇଥିଲେ ମୁଁ ମଧ୍ୟ ସେ ଅନୁର ଆଜ୍ଞା
ସେପାରେ କହୁଛି ଆଉ କଣ କେତେ allowed same
Item 43.
43 my lord annex 2 is
Similar order, 3 SC/ST, similar.
ହେଲା same order ୟାର annex 2 ଅଛି ହେଲା supplementary
Good to pass.
କୋଉଟା ଡାକ
Pastor Act note 13.
yes
That's matter was hard played minors. Minors kindly have a class to that chart, attached to that rule minors that copy is there with minors.
ଦେଇଛନ୍ତି ଆପଣ
Minors,
ଦେଲେ ତମର ଦେଇଛନ୍ତି
chart nahi, chart ka jo illegal item.
ଓ that is you printing press ର ଯୋଉ government press ର
On the stage of
this one ନା କଣ
border ଥିଲେ
ବଡ ନାହିଁ yes
minors overseer ବୋଲି ଗୋଟେ ଉପରେ ବଡ ହେଡିଂ ଲେଖା ହେଇଛି ତା ତଳକୁ ଗଲା assistant overseer ତାପରେ ଦେଖନ୍ତୁ head reader ତାପରେ section holder ସେ ଏମିତି ତଳକୁ ଯୋଉଟା ଅଛି ସେଇ ପର୍ସନ ଟାକୁ ମୁଁ ପ୍ଲେସ କରୁଛି ସେଇ ପର୍ସନ ରେ
section holder mono section
no then reader in charge branch press machine foreman reader in charge ଏଇ ମାନେ ସବୁ ପ୍ରମୋସନ ପାଇପାରିବେ to the post of assistant overseer but reader in charge ଯଦି ହବ then he will get a promotion to the post of head reader then to the post of assistant overseer. The petitioner was not in the post of reader in charge or head reader, has not got promotion to the post of head reader because there is no existing post.
Yes.
What last state minors required to know about the which provision of the law specified that it should be adhered to. That is what minors required to know that this was urgent minors. Now kindly glance that rule. The Odisha government press industrial employees
rule ଟା ଦେଇଛନ୍ତି ଆପଣ
ଆର୍ଥର ଥିଲା କବିଟା ଗୋଟେ ଜେରକ୍ସ କପି ଦେଇଥିଲେ ଆପଣ ପୁରା ଟୋଟାଲ ଟାର
ନା ଟୋଟାଲ
ଏଇଟା ଦେଇ
yes
minus rule 10
rule ଟା ନାହିଁ এটা ଖାଲି ତା schedule ଟା
କିନ୍ତୁ ମୁଁ ଯେ ପସନ୍ଦ ଦିଟା ଯୋଉ ମାର୍କ କରିଦେବି
rule 10 ନାହିଁ
ଯୋଉ ଦିଟା ପର୍ସନ 10 ର ଯୋଉ କ୍ଲଜ ଟା relevant clause ଟା
every trade that exists on the date of commencement of these rules with its typical channel and hierarchy of posts carrying different nomenclatures is illustrated in the chart and schedule B.
then tapor portion ଟିକେ ତ ନା ସାହାଯ୍ୟ
You college once a person is recruited in a trade at the first point, he will have his promotional channel in the trade as indicated in the chart and schedule B. तो बोलिए ना
ସେଇଟା ନୁହଁ ତ ଚାରଟା ସେଟା ଅଛି ମୋର ଇଥିରେ ଲାଗିଛି ପଡୁଛି ଦେଖିବାକୁ ସୁବିଧା ହବ ସେଇ ଗୋଟାକ ଏଥିରେ ବଡ ହେଇକି ଅଛି I borrowed the book of my brother so that I can do. First, we are concerned about the head reader line.
Yes.
Base level copy holder. He was copy holder. He will get promotion to revisor, then junior reader, then senior reader.
Yes.
Senior reader but a contingency will come. A senior reader may be reader in charge. Reader in charge. Then
it is treated as equivalent.
No, equivalent.
No, senior reader. Now promotion se reader in charge.
हाँ reader in charge भी गोटे ये की रही है promotion कर रहे हैं मुझे देखे भी आगे अपन schedule टार देखे देखे तापर असला head reader हेल्ले जाइकरी promotional channel पाइबे assistant officer से अच्छी senior reader what he says that I will get direct promotion to the assistant officer post of assistant officer this post of assistant officer जोटा कम junior production officer बोली कही चंदी there is no dispute on that सेटिफिकेट तंकर direct eligibility आसुना पर सब में let's now bring to my lord's notice about the schedule. Page 44.
44. 44 nahi hai.
4 rule.
Bohi. 44, yes.
Second proofreading section copy holder, then copy holder do yes for revisor, channel of promotion. Then junior reader, then senior reader, page proofreading. Reader in charge in branch space. This is channel of promotion to the head reader or assistant overseer. Channel of promotion. Then head reader. Head reader remains in overall charge of the supervision of the work of the reading branch. In all its pages, he should be a man outstanding literacy and supervising ability. So head reader itself is a post and is a promotion out. It will be occupied through promotion only. ये reader in charge of head reader को जीवो. ये अच्छी senior reader. यांकर कहवा कथा कि मु reader in charge सीधा junior production officer को consider करा. This is what is the thing. So then what happened? One part my lords required to clarify that whether this is born out of the rule or not. That is what I have submitted. Then second part my lords. My learned sin brother referred to a resolution, earlier resolution of the DPC. Page 20 of the repeats.
Yes.
Page 20. This was the Departmental Promotion Committee. This was held on 27/12/2011. 27/12.
You are referring to page 20.
Page 20.
This is Annexure 1. Annexure 1.
Annexure 1 ना?
Date है 3/10/2008. 3/10/2008.
नहीं तब पढ़ो ये कोड देखिला पढ़ो.
Page 20.
नहीं ये.
এটা Annexure 3 थी.
Annexure 3 नहीं.
Criteria.
नहीं ये जो promotion जो नहीं थी लेकिन. DPC टा है इतना promotion ना.
30 देखो page 30.
मैं सेट तो लास्ट में यही टेबल दी थी गोटे 11/12/2011 गोटे चिट्ठीटा उत्कल यूनिवर्सिटी रेफर करछनी ता देरे ता एनक्लोज अछि मेमोरेंडम फॉर द मीटिंग ऑफ द
Annexure 3 probably.
as the Department of Promotion Committee to be held on 27/12/2011.
So this is just a notice of the DPC. Then the memorandum for the meeting.
DPC. This DPC could not be held because of the reason stated in paragraph 8. Some directions of the Honorable High Court, that is what somebody kept in charge, it could not be acted upon. Last point. Now kindly read paragraph 6. My learned friend refers to one of the clue there, criteria of promotion. This mentions section holder composing, section holder, senior proofreader.
He is senior proofreader.
And machine foreman are eligible to get promotion of junior production officer as per chart showing trade hierarchy post of promotional channel in schedule B. That is not in corroboration of the chart. Wrongly it has been written, or rightly wrongly this has been written. Now, this DPC could not be acted upon because they will not be considered that for the reason that some of the cases were pending before the Honorable High Court, and in view of the Honorable High Court, one PK Mahapatra was allowed to perform the work. So the DPC could not be acted upon. My learned brother also referred to some document relating to obtaining information under RTA Act. There also they refer to senior reader. I ascertain whether there is any resolution of the university that a senior reader can be promoted. No, it is not there. There is no basis of giving this information, but anyway, this information is there. But it is contrary to, it clearly mentions that it is in accordance with the rule. This rule I refer to. Then another DPC was held. That is what my learned brother challenged. This DPC was held. This DPC was held, I have given it in my counter. Annexure A by 2.
Annexure A by 2. Yes. Yes.
But Annexure A by 2, this was a proceeding matters which is under challenge. This was on 1828 to 2013. Members manner the criteria of promotion. They rectified the mistake. Section holder composing, section holder mono, section holder reader, head reader. Head reader. It is rule be coach head reader. Head reader and machine foreman are eligible to get promotion to the junior production officer. Chart showing trade hierarchy schedule B of the Odisha Government Place Industrial Employee Rule such and such 70. I refer to that chart minors. So the criteria for such promotion shall be merit and suitability. Then one person was found suitable and he was given promotion. This man has retired already, being a senior reader. My humble contention minors twofold. We are adopting the rule. The rule itself specified in the chart that yes, if you are senior reader, then you are to be reader in charge. Then you are to be head reader. These two posts are not there. So there is a stagnation. And stagnation, you will be entitled to other benefits like RSAP or MSc, whatever there. But you cannot be considered for promotion zone of, it cannot brought within the zone of consideration so far junior production officer is concerned. This is what is the stand of the university.
Yes. All right. Then I'm closing it.
Yes. On the date of promotion given to the promotion to the opposite party number 4, that has been passed bill 28/1/2000.
All right, I'll consider it. All right. Hearing concluded, judgment reserved. Parties may file their note of submissions, memo, citations, if any, within a week. Yeah.
I will give a copy of the order that the rule.
Rule ta pura de dele bhalo.
More I will give a copy of the.
Xerox kari ke de diyo.
हाँ
Xerox kari certificate de debo ko. Sala weekly list. Supplementary list sala. ଆଉ ଅଛି ଆସ ହଁ ଠିକ ଅଛି ୱିକଲି ଛାଡ଼ କୋଉ ଯାଏଁ ଯାଇଥିଲେ ଆମେ ୱିକଲି ହଁ ଏখানে ଆରମ୍ଭ করে তারপরে ଯିବା ଫୋନ ସପ୍ଲିମେଣ୍ଟ ଦେଖ
Weekly list item number 91.
Sir, weekly 91. Sir, you are for the appellant?
Oh, I am appearing today, Millard. Filing memo.
Yeah. CCO Rao, Leonard Council, Senior Council appears with. What is your good name?
Next Wednesday.
Tarne Prasad.
You are for the petitioner, though?
Yes, sir.
What are the power?
No, no.
I am for the petitioner.
Yes.
Sri C.A. Rao, Leonard Senior Council appears along with Sri G.N. Sahu, Council for the appellant. Yes.
Next Wednesday.
Sri Rao requests for an adjournment. Let's this matter next week. Week commencing 8th July.
8th.
Can
it be before that, Millard?
No, it has to be in the weekly list. If you have any difficulty on a particular day, we can pass it over.
No difficulty, Millard. I wanted short time.
No,
so
doesn't matter.
It can be disposed of short point.
8th July jo weekly list se asibo, any day we can take it up. No, but is it ready for hearing?
Yes.
Mane substantial question of law framed.
Yes.
LCR be called for. LCR aschi na nahi dekha. LCR ଅଛି ତ? ହଁ, LCR. I think LCR is also there. All right. So it is ready. Who's for the other side in this case?
I'm for the respondents, all
Alright.
the three respondents.
So get ready. Yes.
Item 92.
My lords, pass over.
Pass over.
Please.
Item 93.
Pass over.
Item 94.
93 I'm there.
93. Oh. You are for?
I'm for the appellant.
Appellate. Who's opposing you, Mr. Samatrai? Shall we begin?
Last document is heard. I will give my written note.
It was heard. Sorry. Pathad hitantale. Let me see.
Mr. SP Mishra was appearing, then Mr. Bhunia has appeared.
Yes.
That's okay, not.
There was a report mediation unsuccessful ହେଲା. Oh, is this that ଗୋଟେ ଚାର୍ଟ ଫାଟ କରିକି ଆପଣ ଦେଖିଥିଲେ କି ଗୋଟେ ଡାୟାଗ୍ରାମ କରିକି
ରାସ୍ତା ଘରକୁ
ସେ ଯୋଉ ବହୁତ ପ୍ରିଭିୟସ୍ ଆସାଇନମେଣ୍ଟ ଆଇ ହାଡ୍ ହର୍ଡ ଦିସ୍ ନୂଆ ଆଉଥରେ ଆରମ୍ଭ କରିବାକୁ ପଡିବ
ରିଟର୍ନ ନୋଟ ଦେଇ ଦେଇଥିଲି ଆମ ଘରକୁ ରାସ୍ତା ନାହିଁ
I have seen that. You had given some photographs also, if I remember correctly. Yes.
Photographs that there with me.
The dispute is.
ଦି ଭାଇଠୁ କିଣିଲି ବଡ ଭାଇଠାରୁ
ଦେଖୁନାହାନ୍ତି LCR is there. Find out which exhibit do you want? Tell me. Mr. Mishra, you are there in this matter for the respondent.
Yes, ma'am.
Exhibits are there. Which exhibit do you want?
Mr. Mishra has requested me for an adjournment today morning.
All right. Adjournment. The next week next week. Next week next week. How many? Oh, all right. Let's this matter in the week commencing 8 July as per.
Item 96.
pass over.
Pass over.
Item 97.
97 time.
Time level.
Respondent by.
ये appellant कहाँ थे?
काली दिनों टिके नेक्स्ट
नहीं ना हो
कोई भी इन्फॉर्म कर दे
all right 8 July
Item 98.
pass over.
Item 99.
So, honorable respondent, recently were appeared in this case, Lord.
So
It took some time, Lord.
पढ़ी कहीं का सुना थी प्रिपेयर कहीं होना थी केस 2020 मैटर recently कौन
Notice was issued in April 2021. Notice was issued in April 2021.
You are also not ready. You are also not ready.
I am ready. Notice has already been issued and
yeah फिर कुछ नहीं
again.
All right, week commencing 8 July.
Interim order.
Interim order to continue.
Item 100.
This matter of the LCR was called for final disposal.
Notice जाइए ना?
हाँ notice जाइए अदर साइड भी appear
कुछ नहीं
है सब सर्ची खाली next date
deficit court fee
से आगुरु accept है जाइए तापर admission है
admission है जाइए
हाँ admission है जाइए question of law frame है जाइए
ये भाई admission है ना
admission sometimes in February or March it is there.
Fourth of March.
4th of March. This is a matter, my lord. The suit was decreed in my favor. Other side filed in appeal, my lord, for the district forum. That appeal was I succeeded there. My lord, Honorable Justice Das, my lord, was the.
So that's why he is recused.
It had gone to Honorable Supreme Court.
Pass over.
So item number 10.
I am appearing with the respondent.
Completion of party. You are filing an application for impletion of party.
My lord, I am applying for the respondent, my lord.
Who's for the petitioner? Who's for the appellant?
My lord,
All right, pass over. File author to call.
so I know 12.
12. Pass over.
So I don't know 20.
Yes, my lord. My lord, I have filed a delay application, condolation of delay.
Delay application ଆସିଗଲା ତ? मेरे काली ଆସିନଥିଲା ନା? IS 667 of 2024. କେତେ ଦିନ delay?
60 days.
Issue notice to the respondents on the question of limitation by registered post, returnable within 4 weeks. Requisites be filed within 3 working days. List this matter on
The week commencing 12th August.
in the week commencing 12th August.
Polish.
So I don't know 25.
43. Yes, item 25. Anybody? Pass over.
So I don't know 26.
Sorry.
I don't know 27. I don't know 28.
27, I am on BC, my lord. I'm on
27?
BC. Yes, my lord. I'm applying for the petitioner, but the opposite party counsel is not present. Yesterday also, today also is not present, I think. So, ask me next week on any date, my lord.
Next week ହେବ?
Next week TRP ଟା ହେଇଯିବ।
Either TRP ଟା ହେଇଯିବ? Please this matter next week as preferred for. Yes.
I don't know 28.
Lord, I am for the petitioner. Lord, yesterday I was on BC, but I couldn't connect, and my learned senior counsel submitted that both the parties, the husband and wife, are residing together. So, my lord, kindly liberty may be given to if in future any cause of action arises. Is it TRP?
What is your instruction?
There is no instruction, my lord.
So say that. How can you concede to whatever he is saying without instruction?
I have no knowledge about that they are residing
So
together.
you acquire that knowledge.
My lord.
Acquire that knowledge and then come to the court.
My lord.
Please this matter next week as preferred for.
Obliged.
Item 29.
Yesterday I was on BC.
Yes.
To today.
Transfer application.
Transfer application.
कौन है जी? You are the wife.
I am the wife.
You want it to be transferred from which place to which place?
From Rayagada to Barampur.
Rayagada to Barampur. On what ground?
Because I am residing at Barampur. Jaipur to Barampur. I am residing at Barampur and my parents, my father is a retired person and I have threat to life at Jaipur. And
yes, Mr. Mishra.
Well, since 2017 it was filed and stay was granted, and till date the proceeding is stayed.
That is why I do not grant any stay. Very rarely I am granting stay.
My lord, I suggest, my lord, between a middle place because Jaipur and Barampur.
Middle place कौन हो?
Middle place or
Middle place हो? आप virtually appear करिए हो?
Okay.
आप virtually appear करिए जो दरकार. Every day appear करिए दरकार. इच्छी नहीं इधर convenience of the lady is normally taken upon.
This is the section 13 application.
Convenience of the lady. 90
Section 13 now कौन करेगा?
Allow कर BC permission.
हाँ, सीता. The petitioner is the wife of opposite party, and in the present application, she seeks transfer of CP number 55 of 2017, pending in the Court of Learned Judge, Family Court, Jaipur, to the Court of Learned Judge, Family Court, Barampur. The aforesaid case has been filed by the opposite party husband for divorce under section 13 of the Hindu Marriage Act. It is the application for transfer has been filed on the ground that the petitioner has been residing at Barampur, which is at a long distance from Jaipur. Moreover, she apprehends danger to her life. Yes, surely can.
Pleading courage.
Huh?
Pleading
No, pleading the key code. No problem. Moreover, she apprehends danger to her life if she appears at Jaipur. So, Sri Nanda, learned counsel for the petitioner, submits that are you receiving that maintenance amount?
I'm not in touch with the client. She didn't pay 300 rupees. No maintenance was there.
You mean that the
WS file
no, I will not write that.
appear करके WS को already file कर सकते हैं divorce petition.
But I will not get that permission. I mean that it will be highly inconvenient for the petitioner if the proceedings are allowed to continue at Jaipur. Correct. The Abhijit Mishra, learned counsel of the opposite party husband, has opposed the prayer for transfer by submitting that submitting that the petitioner has filed the case only to linger the matter and to harass his client. He further submits that there is no valid ground for transfer. Considering the submissions and the relative inconvenience likely to be faced by the parties if the proceeding continues at Jaipur, this court feels that it would be in the interests of justice if the case is transferred from Jaipur to Hon'Ble. So the transfer application is allowed. Proceedings in such and such are transfers, you notice while portion further, the opposite party husband may see, it shall be open to the opposite party husband to move the court below, seeking permission to appear through virtual mode, if so advised.
And one thing, Premal, since it is a matter of 2017 and she has appeared and filed her WS, proceed by target that case. That CP may be targeted.
Case of the year 2017, the transferee court shall do well to dispose of, to try and conclude the case as early as possible, preferably within a period of 6 months.
Obliged.
Item number 31.
So till Saturday, till Friday it will go. Friday जाएं देखिए रखिए author. Yes.
काली भी पढ़ काली भी पढ़ला आया नथले.
The weekly list पे अच्छी पासवर्ड पे last दिन जहाँ हो.
Item number 33.
If nobody appears, yesterday I told the bar, if nobody appears till Friday रविवार से.
Item 33. Item number 36.
Chalo.
Item number 39.
39. Chalo.
Item number 40. Item 41.
May I please, Your Lordship? I'm appearing for item number 40, Your Lordship.
Item 50.
Yes, Your Lordship.
Yes.
I'm appearing for the opposite party, Your Lordship.
The petitioner is not there, so it is passed over for the day.
Obliged.
Item 41. Item 42. Item number 43. Item number 44. Item 45. Item number 47.
Item 47, there is no instruction from the client. There is a transfer from Jaipur to CORAM, but the learned counsel from the court below has that instructor that suit has been dismissed for default.
But there is no instructions disposed of accordingly with that liberty.
Item 49. Item number 50. Item number 53. Item 54. Item 55.
Passport.
Item 57.
Tomorrow again it will be called out.
Item number 58. Item number 60. Item 61.
Let's pass over for the day.
Item 62. Item 63. Item number 54.
I am for the petition. Item 64. I am for the petition.
Anybody appearing for the opposite party? Inform him, we can take it up tomorrow.
Item 65.
Let's pass over.
Yes.
Item 56.
64. Item 64.
Item 64.
64.
Yes, Mr. Mishra.
In this, I am for the petitioner seeking
Yes.
transfer.
You are the wife.
My lord. Husband filed the application for divorce in the court of Keonjhar to Bonai. My lord.
Family court Bonai civil justice in a division court. That can be done in BC also.
You can appear through virtual.
ଏଟା ବି ହେଇପାରିବ ଅନଲେସ୍ ଟ୍ରାନ୍ସଫର ହେଇକି ପୁଣି ଆଉ ଗୋଟେ ଓକିଲ ଦେବେ ଅଯଥା ଖର୍ଚ୍ଚ କରିବେ
କୌଣସି ତ ତାଙ୍କର ଖର୍ଚ୍ଚ କରିବାକୁ ଚାହୁଁଛନ୍ତି ଆପଣଙ୍କର କଣ ଅସୁବିଧା ଅଛି? I will say that you opposed tooth and nail, vehemently opposed and all that. And I will grant you virtual mode. Hala? The petitioner wife seeks transfer of CP number 122 of 2020 coming in the court of learned judge, family court, Keonjhar, to the court of learned civil judge, senior division, Bonai. The aforementioned case has been filed by the opposite party husband for divorce under section 13 of the Hindu Marriage Act. 13(1)(a). Therefore, transfer has been made on the ground that the petitioner is presently residing at Bonai and which is at a long distance from Keonjhar. She also has a small child and there is no other male member available in her family. So, as such, it would be difficult on her part to travel to Keonjhar to attend the case on the dates fixed. Sri Sethi and counsel for the petitioner submits that considering the inconvenience likely to be caused to the petitioner, the case may be transferred as paid. The PK Mishra and counsel for the PR Mishra and PK.
PK.
Sri PK Mishra and counsel for the petitioner submits has opposed the prayer for transfer by submitting that the prayer for transfer has been made only to harass the opposite party and that no valid ground has been cited in support of such prayer. Having regard to the submissions as above and on consideration of the relative inconvenience that may be caused to the parties if the proceeding continues at Keonjhar, at Keonjhar. At Keonjhar. This court finds that it would be more inconvenient for the petitioner wife. Stop. In such view of the matter, this court is inclined to allow the prayer for transfer. It is directed that such and such. देखिए कता कर दो ऐसे virtual पे ये टा दे दो virtual mode is available everywhere now. Yes.
सेट ट्रांसफर भी दरकार नहीं.
Actually दरकार नहीं पुराना वाला अच्छी ना नुआ वाला को बहुत कम मैटर को एडमिट करा जाउची. Only where there is a chance of settlement mediation को आखिर रखी करा जाउची नॉले. After some years probably this transfer applications thing will go. Yes, देखो.
Item 65. Item number 66.
67 for the petitioner.
Question the other side. Inform करो तो काली नहीं जीवा.
Item number 68.
67.
67 टा.
67.
Both of you are here.
Yes. The petitioner wife filed this case to transfer its case from civil judge senior division Akbar to Jajpur, family judge Jajpur.
Yes, Miss Anna.
Petitioner wife filed this case to transfer filed by the husband. MAT case number 21 of 2022 pending before the London Judge Civil Judge Senior Division Akbar to Judge Family Court Jajpur.
On what ground?
On what ground? Only daughter. There is nobody is there in his family. Depending upon her old father.
Yes, Mr. Mishra, same order. Same order. Same guy, right? खाली जगह उड़ा क्यों है ना? तो virtual mode भी कर दो.
Item number 68. Item number 69.
May please, Your Worship. Your Worship, I'm appearing for the wife. The wife has sought for transfer of a matrimonial case from the family court Balangir to family court Bhubaneswar, Your Worship. She's staying in Bhubaneswar and is independent on her parents.
Yes, Mr. Nanda.
My lord, I am for the husband. I have filed my counter. A lordship may transfer by recording my opposition that two criminal cases are pending at Balangir. That is the behest of the wife. And she is not a dependent, she is a working lady, engineer by profession, and virtual mode and my lord.
That link is there. Virtual mode. In every case, that liberty is being granted, but is there any chance of settlement?
Well, chance of settlement is not there.
All right. I'll allow it.
Whatever will be decided on merits, my lord.
I'll allow it.
Okay. Only at virtual mode and appearance, if not required, my lord, may be discussed.
Great. Unless necessary. It is not necessary. Every date appear only affidavit cross examination of that's all. That is the only time you have to appear. I don't know why this transfer is being sought for. Only to harass. Counsel to the opposite party husband opposes the prayer for transfer on the ground that two other criminal cases have been preferred by the petitioner wife at Balangir.
At Balangir.
The party shall not insist upon the personal attendance unless absolutely necessary. Yes, allowed.
Item 70.
70, yes.
Item 70, my lord, on the last occasion, this honorable court has issued notice, my lord.
No, Mr. Panigiri has appeared. He was there yesterday probably. So, Kali Nava.
Panigiri. Okay.
BS Panigiri, Bhubaneswar Panigiri. There are 24 matter. 24. Interim order achi.
No, interim order.
Yes.
Item 71.
I'll inform him, my lord.
Yeah, inform him. So, I'm just passed it over.
Yes, yes.
Tomorrow we'll take it up.
Yes.
If necessary, we can dispose of.
Item 72.
Yes, Mr. Ponda. Ready?
Yes, madam.
Mr. Mishra, you are there?
Yes, madam.
All right. Everything is ready.
Not yet admitted.
Not yet admitted.
No.
This is for hearing of the, this is for our 41 rule.
Madam.
You will admit it formally. CRB अच्छी सुन लो तब आपको. पर formal admission तो होगा ना.
Again.
What is it? Tell. मैंने admission होगा कि नहीं मुझे जाननी.
Again. The plaintiff is appellant with minors.
Author कौन?
Plaintiff's house and defendant's house are adjacent to each other.
Yes.
Minors over there. Minors. In between the house, there was a sweeper passage since 1951. my vendor has left the same for me, which is a part of my plot, my lord. That sketch map I have also filed and that has been marked as exhibit. The defendant started construction by encroaching the sweeper passage. And I approached on a civil court, my lord. In the evidence, they have categorically admitted, yes, we have encroached this much of area. से जो गलिटे आगे थिला ता ऊपर से फास्ट फ्लोर टाको साजा बाहर करी करछन 4 माला एवं सेतेरे I asked question मु पचारली yes I have encroached and this is very much necessary for my building and all 15 windows have been opened from my side and entire rainwater is falling on my open terrace. So he has admitted. What are the findings I have quoted? I am bringing to my lord's kind notice.
Let us see the issues.
Again, ମୁଁ ଟିକେ ଖାଲି ମୋ appeal में ଗୋଟେ my lord's page 6 ଟା
issue ନ ଧରିଲେ କଣ ଆମେ
issue କିଛି ବି
କୋଣ ଯୋଉଟା ଦେଖଉଛନ୍ତି କୋଣ
ଆଜ୍ଞା କୋର୍ଟ ଅଛି page 5
ନାଇଁ appeal member କୋର୍ଟ ଦେଖିବା
appeal member page
5 yes
issues at para 4 whether the suit is maintained in its present form, whether plaintiff has got any cause of action to bring the suit, whether the plaintiff is entitled for declaration of his right, title, interest and possession over Schedule C land and Schedule C land is a part and parcel of Schedule A land, whether the plaintiff is entitled for confirmation of possession in the alternative recovery of possession of the Schedule C land as it is exclusive belongs to plaintiff, whether the plaintiff is entitled for a permanent injunction restraining the defendant not to interfere in his peaceful possession in respect to Schedule C property, whether the plaintiff is entitled for a mandatory injunction directing the defendants to remove the illegal construction over Schedule C land and demolish the construction of first floor, second floor and third floor standing over Schedule C land and so on so. Now your lordship, para 6 of that page, findings of the trial court. In the instant case, the plaintiff has claimed a declaration that the Schedule C property is a part and parcel of Schedule A property without giving any proper description such as khata number, plot number, area, or also any number as per given by the settlement authorities in order to reach a conclusive point. B. It has been admitted by the witness source of defendant, this is reported defendant and plaintiff that there is a passage and gully having 4 feet width in between the house of the plaintiff and the defendant, but the plaintiff has failed to prove that the said gully or passage of 4 feet is a part and parcel of his own purchased land, that is Schedule A land. Neither the objection nor the cell deed filed by the plaintiff reflects that the common passage of 4 feet belongs to the plaintiff as his purchased land or he is in possession of it on spot visit by the settlement authority. Though it has been admitted by the defendant that he has encroached 2 feet over Schedule C land at the time of construction of his own house, but it has not been put to the plaintiff that he is the exclusive owner of Schedule C land as per the sketch map and has also been admitted about illegal amalgamation of land by the defendant in his own land. In the instant case, the plaintiff has claimed the title and possession over Schedule C land, but has failed to prove the same as no specific plot number, khata number or area has been given by the plaintiff during his evidence and so also the plaintiff is silent about the physical description of Schedule C property. I feel there is no irreparable loss which cannot be compensated in any manner. Plaintiff instituted the suit very soon after construction started and not in any manner acquiesced in the construction. Mandatory injunction directing the removal of the construction is justified. The plaintiff has not claimed mandatory injunction for disturbance of easement by his own possession, which he has failed to prove. Construction of building over own land without order of any highest authority is not illegal. These are the findings of the trial court. Para 7 first appeal court finding. It reveals from the cell deed by Exhibit 1 that there is no mention of boundaries, so also no sketch map is attached to it. Moreover, Exhibit 5, the objection case number so and so filed by Navaganda's plaintiff shows that the admin denied cause of field verification has found that Equation 04 decimal Gully Rasta is the part and parcel of plot number 1337 and during Khanapuri stage, said passage has been amalgamated in half plot number 1340 and accordingly, the said Gully Rasta has been separated and the boundary of suit plot number 1337 and 1338 have been corrected. It further reveals from Exhibit A that the settlement authority has enhanced the purchased land of defendant from 72 decimal to 88 decimal, ignoring the Amin report by the Exhibit 5. This is vital, Your Honor. The defendant has also not cogently proved on which basis the said area has been enhanced. The evidence of plaintiff also reveals that he is in possession of excess area of 5 decimil than his actual entitlement. No such document is forthcoming from the side of the plaintiff that he is in exclusive possession of the disputed passage. In the instant case, the sketch map attached to the plan is not sufficient in absence of the village map in order to hold the clear and distinguishable area of land claimed by the plaintiff. The plaintiff ought to have filed map of the suit property annexed to the plan. In this respect, can an effective decree for recovery of possession be passed in the absence of necessary pleadings in respect of the identity, extent, and measurement of the disputed land? The sketch map appended to the plan as shown was not clear as to the length and breadth of the enclosed area by the defendant. The plaintiff has also not taken any step for measurement of the land alleged to have been enclosed by the defendant through a surveying commissioner. My lord, let us pause here for a moment. Very outset, my respected submission before my lord, before the trial court, I had filed an application deputy surveying commissioner, but the London trial court has not passed the same, passed any order. So this finding which has been given by the first appellate court, that is without going through the document.
That application under Order 26 Rule 9 was rejected.
No order has been passed.
So you should have challenged it.
I mean, मुझे लिखी जी, ground में नहीं जी, substantial question of law में नहीं जी, जोड़ा first appellate को कहले. Apart from all these things, lordship, there are several documents. जोड़ा कहले,
but will in the absence of necessary pleadings in respect of the identity of the land, will Order 7 Rule 3 not be a bar?
Again, Order 7 Rule 3, when a decree will be passed under what basis? Again, that also can be amended. But three things: the London trial court and
amendment could be second appeal. Amendment could be remanded. You failed at the appropriate time. 26(9) the application order you did not challenge the inaction at that point of time. If you have filed an application, no order was passed. You have challenged.
Courts it will be dealt at the time of judgment. से कहले ना किछि ऑर्डर करना दी एंटर ऑर्डर सीट होजी हजूर आसी हजूर काई देखि फर्स्ट अपील कोर्ट होजी से कथा कहले एवं आउट जिंस कहले व्हेन आई फाइल ऑब्जेक्शन केस बिफोर सेटलमेंट अथॉरिटी दैट माय एरिया हैज बीन रिड्यूस्ड एंड द एरिया ऑफ द डिफेंडेंट हैज बीन एनहांस्ड 72 to 80 हेजी सेतिर कोर्ट राइट टू होल्ड कहले डिफेंडेंट फेल टू प्रूव व्हाट आर द डॉक्यूमेंट्स अपॉन व्हिच ताके एरिया बढ़ी छी सेरा करन बट इन माय केस द लॉ बोथ द कोर्ट्स विल हैव होल्ड दैट Amino Muchi Kichi then Amino, the report of the Amin has categorically said, yes, my area has been reduced and this should be deducted and it should be recorded in my favor. That is, I am replacing. The Amin has given specific
anyway, you have referred to that.
I am that is marked as exhibit 5, my lord.
No, paragraph page 90 exhibit 5. Objection is that the Amin denied cause of field verification and found that acre 4 decimal Goli Rasta is part and parcel of plot number 1337. Shoot plot. And during Khanapuri stage, said passage has been amalgamated in Hall plot number 1340.
And submitted report that this aspect has not been considered by the London courts below. Therefore, the judgments are vacated. It again, se khali se padi change jara mu khali se duru gote line padi. Again. मेढ़ संशोधन नूतन खाता प्लॉट यातायात गली रास्ता को आंभ नाम इट दिस इज प्लीडिंग ऑफ द प्लेंटिफ एणु साबक प्लॉट 427 428 किछि अंश रे रास्ता थिबारु हाल प्लॉट 1340 1341 रे एही गली रास्ता खानापुरी समय होइथिला ताहा एस चिन्ह दिया जाई हाल प्लॉट 1340 रे मिसाई दिया जाई अछि किंतु ताहा 1337 रे 37 बाबद होइथियो 1337 माय प्लॉट बाबद होइथियो एही गली रास्ता को पृथक करा गला और सरजमीन मुताबिक हाल प्लॉट 1337 मेढ़ हाल प्लॉट 1338 को संशोधन करा जाई ट्रेस पास दर्शाई दिया गला हाल प्लॉट 1340 को पृथक करा गला हाल प्लॉट 1340 88 स्थले 86 ताकर जोटा हेला को एवं नेक्स्ट पेज रे यू नंबर 14 अमीन रिपोर्ट जे केस नंबर 534 सोनसो हालपट 1338 63 स्थले 62 हालपट 1337 36 स्थले 40 करा जाई बाबी दखल दलिल मुताबिक हालपुर 1337 और हालपुर 1340 में 1883 को 10 कलम मुताबक आसामी माने पृथक खाता करा इत्यादि जोटा मोर कमी से कहले मोर पृथक खाता करिया को 1340 रही 1883 this side dismissal को माइनस करी करिया को दैट गली रास्ता that has not been done. This is the report of the mean, but both the courts below have heard that I have not filed any document. That happened, my lord. The sketch map which has been filed with the plan.
Court will admit it. Will admit it since Mr. has already appeared. LCR is there.
Okay.
Next week is okay, sir.
Okay.
What do you say?
My difficulty is I don't have the document or any pleadings or document.
I can adjourn it to another date.
NCR will say.
Yes. You come with a pen drive?
Yes, ma'am.
Heard Sri Bhaskar Panda.
Next week.
As is convenient, don't worry. Heard Sri Bhaskar Panda, then counsel for the appellant. There is the impugned judgments. Considering the grounds raised, the second appeal is admitted on the following substantial questions of law.
Page 15 again.
देख रहे हैं ये ଦେଖନ୍ତୁ ये जो 2 II रे जोटा अछि II लिखा होने वन नाम लिखा हो एठी जो II अछि II लिखा अछि whether the findings of the court below to the effect that the plaintiff failed to prove his ownership over schedule C land is justified. Tapare IV whether the finding of the Leonard First Appellate Court to the effect that the plaintiff failed to measure the suit land by deputing a surveying commissioner is correct in view of non-passing of any order on the petition on such petition filed by the plaintiff in the court below. Say dita case dita ye rahi jo. No notice need be issued to the respondent as he has entered appearance. Respondents. देखिए मोरी की चिंता में नहीं.
Is the original defendant has died? Is the legal heirs?
Respondents. Accordingly, as they have entered appearance through Sri Sandipani Mishra, learned counsel. That copies of the appeal memo. Copy of the appeal memo has already been served upon Sri Mishra. LCR is available. So, the Mishra submits that he does not have copy of the lower court records and therefore requests for supply of soft copy thereof. Office is directed to furnish soft copy of the LCR to Sri Mishra in a pen drive. केबे करिए कौन तो?
First week.
Is this matter in the week commencing? Is this matter in the week commencing 8th July? This will come a little down in the list. But we can.
Which sir wrote it?
Yes. Negative.
Item number 75.
May it please, Your Lordship. We have for the plaintiffs before the Leonard Trial Court filed a suit for declaration of a registered partition deed under Exhibit 2 as void.
Declaration
of a registered partition deed, Your Lordship.
I didn't understand. Declaration of a partition deed, man?
Of a registered partition deed to be void. A partition deed was executed. We applied for declaration of the same deed.
Document.
Lordship. And thereafter order a fresh partition. That was dismissed, Lordship, by judgment dated 7/1/2019.
And that has been confirmed.
Lordship, confirmed in the sense that against the same we went up in review under section 114. We filed a review petition, albeit not properly advised, but we filed a review petition and perused it in good faith. Thereafter, it was dismissed on 14/9/2022 following which we preferred an appeal. Now that appeal has been dismissed on the ground of limitation, Your Lordship.
Okay.
So our simply case is that we agree that there has been a
Section
delay.
14
Lordship of the limitation act.
Limitation act you are referring to. Will
Lordship.
it apply here?
Principles would apply here because we have perused, will not apply per se.
Was it not raised before the court below? How is the court found? What is the
Lordship,
finding of
the
the court?
impugned judgment at running page 21 of Your Lordship's brief. Starts at running page 21.
Place it. It's a short order. Place it.
Lordship. This order arises out of a petition dated 10/10/2022 filed on behalf of the appellants Kailash Niyal and others under Section 5 of the Limitation Act to condone the delay and admit RFA number such and such. The brief facts of the case is that one Ganesh Niyal and three others filed civil suit number 9 of 2013 against Prema Niyal.
Go to काम करो तो अपना आसन सुन. यही का सुन. Page 23 का सुन.
Lordship. I'll place the operative portion, Lordship. I have heard the counsels for the parties on limitation petition. The office note shows that there is a delay of 1033 days in filing the appeal. If the limitation period from 15/3/2020 to 2/10/2021 will be excluded as per that INRE so-moto extension of limitation.
COVID-19.
Lordship. Still then there is a delay of 767 days in filing the appeal. But the aforesaid privilege may not be available to the appellants. I must clarify, Your Lordship, that this delay was condoned till the end of February of 2022 and not 23/9/2021 as the learned.
Extension is
subsequent.
That we will find out. That is not an issue. Yes.
But in the aforesaid privilege may not be available to the appellants as because the limitation period for filing the appeal has started prior to COVID-19 pandemic. Lordship. That has been
say you decision regarding so-moto extension of the that. So the cause of action must arise within that period of limitation after February date is
March 15, 2020.
March 15 automatic condonation. Anyway. So if that COVID-19 part is taken up, then only section 14 is there.
Lordship.
Let us see.
Another also we said that the limitation period to file a regular first appeal is 30 days from the date of judgment. The learned counsel for the appellant cited the case laws under such and such and submitted that the period of limitation prescribed for making an appeal gives rise to a right in favor of the decree holder to treat the decree as binding between the parties. The other consideration which cannot be ignored is that if sufficient cause for executing delay is shown, the discretion is given to the court to condone the delay and admit the appeal. The discretion conferred on the court should be exercised to advance substantial justice. I have gone through both the case laws and found that in those cases the appellants have explained the delay satisfactorily. But in the instant case, simply it is stated in the petition that the appellants could not be able to know the result of the suit due to lack of information from their lawyer, Sri Jagannath Sabha. Actually, we say that there was also a delay in filing the review petition by 5 months by virtue of the fact that we had explained therein and also in this limitation petition that we were unaware about the passing of the final judgment in the suit. The moment we came to realize the same, instead of appeal, we were advised and we preferred a review petition.
He has not mentioned anything about the review in this order.
That's just there. It's there. Moreover, the petition filed under Section 5 of the Limitation Act is not supported with verification or affidavit by any party. Then in the case of Ramlal Motilal Chotilal, wherein it says that the grounds on which delay can be condoned. Now, page 25, Your Lordship. In the instant case, the reason for delay in filing the appeal explained by the appellants is not excusable and not satisfactory because of the fact that they simply stated that due to lack of information from their lawyer, they could not be able to know the result of the suit. Moreover, without having any merit, they preferred CMA number such and such before the learned senior civil judge Nuapada, challenging the judgment and decree passed in civil suit number 9 of 2013 to review the same. On calculation, he says that there was no merit in the. We agree there might not have been merit, but we have pursued the same in good faith, Your Lordship. On calculation, it is found that there is a delay in 1333 days, which is more than 3.5 years. It's not supported by an affidavit or verified, so I do not find a reason to condone the delay. Now, this review, it continued till 14/9/2022.
Final review. When was the suit decreed?
The suit was decreed, Lordship.
Repeat करना dismissal each में.
Lordship. Judgment dated 7/1/2019 and decree dated 8/1/2019.
8/1 গোটা দিন পরে
18/1. I'm sorry, Your Lordship.
Yeah,
I beg your pardon. 18/1/2019.
So review filed.
Review was filed, Lordship. Exact date.
Hmm.
19/6/2019, Your Lordship.
That should have been filed within 30 days.
Lordship. Therein we had explained the reason that we were unaware about the judgment, and also there was a strike at the bar therein from 15/4/2019.
15/4 one after your limitation is over.
Lordship.
So that is of no help to you.
We have specifically stated that we came to know about the judgment.
Review filed on 19/6. Review disposed of on?
Review disposed of on 14/9/2022.
First appeal filed on?
10/10/2022. Since we had not been intimated by our conducting counsels, Lordship, there was a delay, and in good faith we have perused.
Nowhere you have mentioned about section 14 of the Limitation Act. In your petition, I've read it entirely.
That's it.
In the meantime, I do not find anything. You have gone for the land acquisition case. Substantial justice versus technical considerations. That cannot be a substantial question of law.
Cartesian judgment. Apart from that, there is another judgment that I would place my reliance upon, wherein says that mere wrong mentioning or not mentioning, or even non-direct application
There is no explanation. There is no valid explanation. I'm not at all on that point. If you come out with a valid explanation, it can be considered. Whatever may be the quantum of delay, it could be 3 years, it could be 10 years. It doesn't matter. But you must come up with a definite explanation. You see, your suit was decreed on 18/1. 18/1/2019. You filed a review on 19/6. That was by itself delayed.
We explained that we had no idea about that the judgment had been passed.
Let us accept that for a moment. Was the delay condoned in that review application? Obviously, it must have been condoned.
Review application was disposed on merit. Dismissed.
But I don't know, where is that order? I will see. You must satisfy the court that the delay in filing the review was condoned. Then only you can seek extension of the period of limitation. Exclusion of the period of limitation, rather, section 14.
That judgment I have not gone through fully, but the last portion I will place. The court is to ascertain as to whether the mistakes or were error apparent on the face of the record while passing the petition for review. Review power cannot be exercised on the ground that the decision was erroneous on merit.
No, I'm not asking that. You have to show me the first order. First order of the review, when the review application must have been admitted. Otherwise, it could not have been disposed of on merits. So, it would have been admitted only by condoning the delay. There is a delay of about 5 months. So, if that delay has been condoned, so the period continues. One can consider. So, where is that order? Review order.
That order.
Come tomorrow? Come tomorrow.
Some time I have to get those documents. I don't have. I have the review judgment, but that particular order condoning the delay. But in fact, in the review judgment, there is an observation that there is barred by limitation. But thereafter, he has gone on to dispose of the issue on merit.
That is why I want to see the order condoning the delay. Anyway, all right. Pass over for the day. Tomorrow. You contact the lawyer over phone. Yes.
Item 76.
How's it? Anybody available? When both sides are there?
Number 87 can be taken 1 week.
1 week after?
Again.
Upon you are for the appellant, Mr. Mahapatra?
I am for the appellant.
All? You are there, Mr. Mahathi?
No, sir, 84 at time.
No, 87 is all.
Again.
87, you, when do you want?
1 week after.
Is this matter in the week commencing?
15th July.
15th July. 15th July.
18th July.
15th.
ମୋର
Yes,
ସେଇ
Mr. Samarth.
86 ଟା ଥିଲା ଟିକେ ଇନଷ୍ଟ୍ରକ୍ସନ ନେଇକା
6. 2006 matter, all right. This matter in the week commencing?
15th July.
Yeah? 15th July.
ମୋର 84 7.
84 भी same कर दो. 15 July. Yes, sir.
Item 88.
88. Yes.
1 week time to be granted to.
This matter in the week commencing? 7 July? No, कितने से ना? 8th July.
8th July.
माने in the week commencing. बाकी remaining matters pass हो कल ऐसे